Woo! To go with it if you want to send that.
The order for the special board meeting of the Board of Registration for Professional Engineers and Land Surveyor. It is August 8th, 8 a.m. and we are at the Crown Plaza Hotel at SeaTac. I am going to have us go around the room and introduce ourselves for the roll call. And then we'll have anybody that's on screen. So Greg, would you start us off, please?
Good morning. My name is Greg Sieberstein. I'm the Communication and Outreach and Education Manager.
Shannon Gillespie, board staff. Chris Horton, Deputy Director.
James Wangler, board member. Aaron Blaisdell, board member.
Dave Eden, board member.
Maureen Jackson, board member.
Doug Peppers.
Marjorie Lund, board chair.
Ken Fuller, staff.
Bonnie Kramer, board staff.
Jill Short, staff. Mackenzie Warrett, board staff.
Bryce Dickinson, board staff.
Okay, and that's everyone in the room at the moment. Online, we have
Just looks like Mr. Harney online.
Mike.
Yeah, good morning. Thanks, Marjorie. Mike Harney, board member.
Please see your
Mike.
square on the screen, but we don't hear you yet.
Can you hear me now?
Trying to talk, please.
Let's make sure we are set up too.
Everybody has to see, you know, can I just say that?
Oh,
Agreed.
Green on. Oh, you're down.
Let's see.
Oh, okay, thanks, good.
Output, echo, input, echo. Let's try that one more time. Testing, Mike, can you hear us? Can we hear you?
I can hear you guys fine. Can you hear me?
Mike just went off. So,
Yeah. Let's see.
He's got two cases to read.
Yeah, he does.
Yeah.
Oh, he can hear us. It's us. So let's see. I see it did not. The owl. So bear with me. We'll check that stay. Owl. Owl. Okay, Mike.
Yeah, can you hear me now?
Thank you for
Yeah.
troubleshooting.
So it wasn't your fault.
It was us.
I'm happy to hear that. I don't have to get an IT hand slap. Mike Harney, board member.
Thank you, Mike. I need a motion for the order of agenda.
so we,
Second.
Moved and seconded by Aaron and Jim. Is there any discussion? Any additions? All those in favor of the motion to approve the order of agenda, please say aye.
All right.
Opposed? Okay. We will now go into an executive session pursuant to RCW 4230-110, and for the purposes set forth therein, the board will move into executive session portion of the meeting to consult with our board attorney to discuss matters related to enforcement and cases in current litigation. The executive session, thinking that this will give us plenty of time for for executive session and a short break. So we will be back in open section at 9:30. Mackenzie, will you please excuse any guests other than Mike and lock the meeting? Will you start the recording?
We are good. And one last thing before, I just got to unlock and close that.
Okay, we're back in open session. It is 9:30. And I am going to look for a motion to approve the June 13th, 2024 meeting minutes.
I move to approve. Yeah. June meeting minutes as written.
Second. All right, we have a motion with Doug and second with Dave to approve the meeting minutes from June 13th, 2024. Any discussion? All those in favor say aye.
Aye.
Opposed? Abstain. Abstain, yes, thank you. All right, so that's the minutes. Do we have any public on the call?
We do not.
So then I am going to refrain from reading the public comment note. And that takes us to item 3.1, case deliberation. And Jill, you'll tell us the case numbers.
Okay. The first case is number 2024-03-0624-00 and Mr. Harney is the case manager.
Thanks, Joe. The complaint summary here is that the complaint alleges that the respondent, a Washington State licensed professional engineer, violated WAC 196-27A-020 with specific regard to a registrant's obligations to the public. The complaint alleges this violation occurred when the respondent's firm, under the respondent's professional seal, misrepresented their qualifications and accreditations to perform laboratory testing of rock specimens taken as part of a Seattle area infrastructure project. Facts. The contractor for a Seattle area tunneling project encountered a boulder during tunneling operations that damaged the tunnel boring machine. To investigate the strength of the encountered boulder as it relates to a potential differing site condition claim, the contractor core sampled the boulder and transmitted those cores to the respondent's engineering firm for strength testing. The contractor subsequently issued a claim of differing site condition against the owner based on the tested strength of the rock core samples exceeding the maximum expected value provided in a project geotechnical report. The complainant alleges that the owner's review of the testing report authored by the respondent's firm identified deficiencies in the testing, including lack of documentation of test procedures and lack of adherence to standardized test procedures. The owner then investigated the respondent's firm's qualifications to perform the required tests and allegedly discovered that the firm was accredited by AASHTO for several tests and quality standards, but was not accredited for the tests performed, ASTM D4543 or ASTM D7012. The owner subsequently requested documentation that the respondent's firm was qualified to perform the testing and that the testing had been performed in adherence with the stated test standards. The owner also requested documentation as to the respondent's firm's specific accreditation for the two test standards in question. The respondent provided a letter to the owner stating that they were accredited by AASHTO for ASTM quality standards, which are ASTM D3740 and ASTM E329. The respondent's letter did not state that they were accredited for ASTM D4543 or ASTM D7012. The complaint alleges that the respondent's letter stated that these ASTM quality standards imply accreditation in the individual test standards, in other words, ASTM D4543 and ASTM D7012. It is common practice for materials testing firms to hold general quality assurance accreditations for their testing facility. Further, it is common practice for AASHTO to perform the accreditation for a variety of test standards, including ASTM. It is not common practice for all materials testing laboratories to hold test-specific accreditation for all tests that they perform. As to the facts presented with respect to the complaint that the respondent misrepresented their qualifications and accreditations, violating WAC 197-27A-020, I do not find evidence supporting this claim. In the evidence presented, the respondent did not, falsely or otherwise, claim that their firm was accredited in ASTM D4543 or ASTM D7012. Therefore, I'm recommending this case be closed with no further action.
May I have a motion?
Move to accept the case management recommendation.
Second.
All right, we have a motion by Dave, seconded by Aaron to approve the case manager's report for 2024-03-0624. Is there any discussion? Hearing none, all those in favor of the motion, please say aye.
Aye.
Opposed? Motion passes.
Marjorie, just note for the record, the case manager abstains.
Thank you. Jill?
Okay, the next case is 2024-04-0935-00ENG, and Mr. Harney's the case manager.
Thanks, Jill. The complaint summary here is that the complaint alleges that the respondent, a Washington State licensed professional engineer, engaged in unprofessional conduct practice during his role as the chair of an engineering panel of experts, EPOE, for a dam project located in a foreign country. The complainant, a member of the EPOE, had a professional opinion that differed from his fellow panel members on an aspect of the project, risk associated with a rock slide. The complainant expressed their opinion to the panel and to the project client. The panel chair, the respondent, prepared and distributed a first draft of the panel's project report containing contributions from all panel members to the EPOE members for comment. Some panel members expressed disagreement with some of the complainant's opinions about the rock slide, as stated in the first draft of the report. After synthesizing comments on the draft from all panel members, the respondent prepared and distributed to the panel an updated draft of the report that the complainant alleges modified their opinions and added additional technical statements. The complainant objected to these modifications and requested that these modified statements not be attributed to them. The complainant requested that their name be removed from the panel's report unless certain statements were changed to reflect their opinion. The respondent noted to the complainant that diverging opinions sometimes occur on such panels, and that the panel's report must convey the overall panel's opinion to the client while noting any differing opinions. The respondent offered multiple options to resolve the issue, including attaching a separate document from the complainant to the panel's report, clearly identifying the complainant's points of disagreement. Ultimately, the report was issued without the complainant's signature or a separate attached document from them per request from the respondent, or per their request to the respondent. My apologies. The report did include a paragraph indicating which statements and paragraphs the complainant objected to. In their response, the respondent noted that panels such as these are commonly formed for large infrastructure projects, and that such panels are always formed of individual engineers or experts, usually 2 to 8 members, and that when the panel publishes a report, consensus is always sought, but occasionally a dissenting opinion may be included. The respondent also insinuated questions as to BORPL's jurisdiction in this matter, as, among other items, the project is not in Washington State, the client is not an organization in the United States, and that the EPOE did not perform, check, or supervise, or direct any design. Facts. The case manager finds that BORPL's jurisdiction does extend to this matter, as the respondent is a Washington State professional engineer, and the respondent's participation in the EPOE meets the definition of, quote, practice of engineering, unquote, in RCW 18.43.030. The complaint alleges, quote, unprofessional conduct / practice, unquote, on the part of the respondent, and that the respondent should have respected the complainant's opinion above those of other panel members. The documentation provided by the complainant, including correspondence with the respondent, as well as the panel's report, indicate that there was a clear difference of opinion between the complainant and other panel members on the risk associated with the rock slide. As a body, the EPOE panel was to issue a singular report, as is typical for such panels or boards. It is clear from the correspondence that the respondent offered the complainant multiple options for addressing their dissenting opinion in the panel's report. Further, when it became evident that the complainant was uncomfortable with the content of the report, their name was not only removed from the report, but a paragraph was included noting their dissent and to which specific items they disagreed. I find no evidence of unprofessional conduct or practice on the part of the respondent based on the evidence presented. Therefore, I'm recommending this case be closed with no further action.
All right, may I have a motion to accept the case manager's report?
So second.
Thank you, Jim and Doug. Move to accept the case manager's report for 2024-04-0935-00 ENG. Is there any discussion? Hearing none, all those in favor of the motion, please say aye.
Aye.
And opposed? Motion passes.
Marjorie, just for the record again, the case manager abstains.
Thank you. All right, next case, Jill.
Next case is 2024-05-1023-00 ENG, and Mr. Hendrickson is the case manager.
Thank you. Can change windows to make sure I get enough stuff in. Thank you. This is the case where the respondent was contracted to design a residence. Following completion of design during construction by the constructor, the owner of the residence passed, with property ownership reverting to the living spouse. Complainant is offspring on behalf of the new owner. Complainant and owner deemed there to be significant defects in house design and construction, initiated court action for recovery from the constructor. Complaints against the respondent alleged that the respondent was receiving compensation from more than one party regarding that design and regarding being an SME on the design, on the construction in aspects for the constructor in court. The respondent failed to respond to inquiries from the complainant during the time that actually the respondent was an SME in the litigation. The respondent was alleged to not be objective and truthful, failing to provide detailed constructive documents. The respondent aided and abetted unlicensed practice of engineering. The respondent was not objective and truthful in that one violation of 27A of 21E regarding court testimony about trusts and framing bidding modification. The allegation of that the respondents failed to maintain competency, practice in violation, claiming that the respondent erred in application and selection of beams in the design. Complainant believed did not meet design needs. Alleged that respondent offered or accepted compensation in violation of 3010 to 19627AO 3010 regarding expert witness testimony rather than material witness testimony in court. And the respondent used privileged information in court representation. Violation of 62712 and alleged respondent demonstrated incompetency with regard to failure of the design to select exposure seat wind load calcs for a 30-foot escarpment. So the facts, investigation, and case manager was that there were extensive communications with the complainant and open and forthcoming responses by the respondent. Those detailed that the general concept of being devolved with as the SME court. As and having done the designs, the respondent had no involvement with the constructor of the completion design, with a couple of limited exceptions. And that was that the respondent was advised by the constructor that the constructor had modified brackets to fit within the framing, and that the respondent had assessed in their judgment believed it did not compromise the design. Modification of the brackets by the constructor in this manner also would not constitute aiding and abetting the unlicensed practice of engineering as alleged. And an allegation that the respondent didn't file with a change with the permitting authority. Said the permitting authority was aware and accepted the change. It would have been the scope of the constructor, not the design agent. So no violation of truth of design. Respondent was requested to act as an SME on design on behalf of the constructor during the tort case. This position was accepted by the court, and therefore no violation of truth in this compensation of responsiveness is found by the case. Respondent's assessment of bracket changes during construction, selection of beams, and the design and conduct of wind load helps demonstrate application of the structural engineer's professional judgment that was not in violation of competency. This case manager recommends closure.
Thank you. Do I have a motion to accept the case manager's report?
Great.
So I have a motion by Aaron, seconded by Maureen for case 2024-05-1023-00 Is there any discussion? Hearing none, all those in favor of the motion, please say aye.
Aye.
Opposed?
Case manager abstains.
Case manager abstains. Thank you. Next case, Jill.
Okay, that one is 2024-1305-00ENG, and Mr. Hendrickson is the case manager.
You can make sure I was. The respondent was in responsible charge of a soil contaminant investigation at a residence following removal of an underground heating oil tank at the request of the home. Complainant believes that the soil investigation drilling fractured a 77-year-old French drain, resulting in water intrusion into the home basement. Primary basis for communications with Discord were related to home insurance claim regarding the water intrusion. The complainant alleged that the respondent was practicing professional engineering without a license, that the respondent company failed to respond to and communicate with other involved contractors and failed to respond with their license. The respondent's inspection documentation was alleged to be inadequate. The respondents alleged to have misstated the types of definitions of water types within a. The respondent did not provide critical or complete evidence regarding materials construed in another portion of the property. With investigation and review of materials and information and communications, the primary point of contact in the conduct of the on-site work was through this respondent, who had not been licensed until the day of inspection, previously an EIT. Work working under the direct supervision of an engineer of record. This respondent was working under the direct supervision of the EOR, who was licensed at all times of work conduct and report generation. Respondent was the point of contact for the work scope, but was not the EOR. So as the point of contact, they did not provide their license number, not having it in hand. So contact the other subcontractors wasn't relative to the scope of the engineer's work. And that dealt with the insurance claim with the insurer requesting credentials of all parties. The finished work product was sealed as complete and professional. Responded to the EOR product and assessment use of terms related to water sources was adequately provided, complete, but has no relevant bearing upon the injury work product. Soil and investigation studies demonstrated the French drain had been bypassed in 2011, presumably due to flow failure prior to this, with drain spout extensions installed by the complainant to move precipitation away from the foundation. And the groundwater was estimated to exist for approximately 34 feet below grade. As such, the EORs, rather than the respondents' professional judgment that the drilling could incur French stream damage, resulting in flooding in the basement. Without any evidence of foundation wall failure or water pounding at the foundation walls, was that an internal water source was responsible for water presence in the basement. The respondent's engineering product did not reflect information regarding live camera records were requested. As such, were not created, nor imagery of purported clay fragments some distance away from the French drain, nor depict several of the borehole locations. However, none were felt to bear upon the respondent's professional judgment regarding contaminant depth, nor extent, which were consistent with the respondent's work. It is this case manager's recommendation to close for the action.
All right, may I have a motion?
So moved.
Second,
Second.
I have a motion by Jim, seconded by Dave to accept the case manager's report for 2024-05-1305-00 ENG. Is there any discussion? Hearing none, all those in favor of the motion, please say aye.
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 Opposed? Sorry, opposed?
Case manager abstains.
Case manager abstains. Motion passes. Thank you. Jill?
Next case, 2024-06-1415-00 E&G, and Mr. Hendrickson is the case manager.
Although different in month and basic case number, same complaint dealing with the respondent who was the EOR in the last case. The respondent was in responsible charge of the soil contaminant investigation following the removal of an underground heating oil tank. Complainant believes the soil investigation fractured a 77-year-old French drain, resulting in water intrusion into the basement. The primary basis for communication with this court were related to homeowner insurance claim regarding the water intrusion. Complainant filed complaints against respondent. I'll say cut and paste. Respondent was practicing professional engineering without a license. Respondent company failed to respond to communicate with other involved contractors and failed to respond with their license number. The respondent's inspection documentation was inadequate. Respondent misstated definitions of water types, and the respondent did not provide critical or complete evidence regarding materials construed to be clay pipe from the French drain. Again, the facts, the primary point of contact On-site work was through a party which was not licensed at the day of inspection. The work was under the direct supervision of this respondent. The respondent was licensed at all times of work conduct and report generation. The person complainant described was the party under direct supervision for on-site. The respondent was not the point of contact for the work scope, but was the engineer of record. That point of contact did not provide a license number that was not in hand at the time. Contact with other subcontractors wasn't being relevant for the respondent to adequately complete their work scope to their professional judgment. In context, that was the insurance claim with an insurer requesting credentials. All parties. The respondent's finished work product was sealed as complete to the professional judgment of the respondent, and the respondent's product and assessment use of terms for related water sources was adequately provided in the complaint, but has no bearing upon the engineering work product. Soil investigation demonstrated that the French drain had been bypassed in 2011 with drain spout extensions installed by the complainant to move precipitation away from the foundation, and that groundwater was estimated to exist approximately 34 foot below grade. As such, the respondent's professional drilling, professional opinion, that the drilling could not incur drain damage resulting in flooding of the basement. Without evidence of foundation wall failure or water pounding foundation walls, was that an internal water source was responsible for water presence in the basement. So the engineers, respondents, did not reflect information regarding live camera records as such were not created, nor imagery of reported clay fragments some distance away from the French drain, nor did they depict several of the borehole locations. However, none were found to bear upon the respondents' professional judgment regarding contaminant depth nor extent, which were in the scope of the respondent's work. This is case manager's recommendation to close this.
Move to accept the case manager's recommendation.
Second. All right, I have a motion to receive the case manager's recommendation for 2024-06-1415-00 as made by Dave and seconded by Maureen. Is there any discussion? Hearing none, all those in favor of the motion, please say aye. Aye. Opposed? And abstain?
Case manager abstains.
Thank you. Motion passes. Jill, we have one more.
Yes, and it is 2024-05-1071-00 LSB, and Mr. Hendrickson is the case manager.
Thank you. The respondent's company was hired to conduct a survey of the complainant's residential property. Field work was completed within 3 days and negotiated survey fee paid. Complainant filed complaints against the respondent that the respondent was hired and paid to complete a survey, but then did not promptly complete the survey filing or timely communicate. Facts were the respondent wasn't responsible charged with the survey involving found monuments, corners, line stakes, and a shed, which was the complainant shed, encroaching upon the property. Respondent's crew conducted communications with the client, the complainant, and completed the field work survey within 3 days of hire. The complainant initiated communications pursuing completion of the ROS when the complainant felt the product should have been forthcoming. Complainant filed a complaint through about 7 months with the state, about 7 months after field work completion, and with what was deemed to be unsatisfactory communications. Following complaint receipt, the respondent reached out to complainant, transmitted a preliminary ROS for review to the complainant, and filed the ROS the following day at respondent's cost. The respondent reported issues which delayed, this is in the context of communications and investigation, reported issues which delayed completion of the survey, including issues expecting to lead to retirement, but did communicate with the complainant upon recognition of the communication issues and did file an ROS with the county at respondent's cost. The closing communication with the complainant generally reflected concern with the extended time required to complete the survey, growing belief that the complainant had been scammed, and concern for the potential that other clients may be impacted in similar matters. The respondent's prompt address of unfulfilled contract work demonstrates to the case manager understanding of the need to perform professional survey, meeting the obligation, being honest, fair, entirely faithful with the public and their clients and other licensed professionals. Respondents filing the ROS at their own cost to the perspective of the case manager is demonstrative of commitment to be honest and fair, to serve the client the best possible at the time the respondent became aware of miscommunications and inclusion. It is this case manager's recommendation to close with no further action, communicating to timely respond with the client. Come back to the
May I have a motion to accept the case manager's report?
Second.
All right, I have a motion and by Aaron, seconded by Maureen to accept the case manager's report for 2024-05-1071-00 LSV. Is there any discussion?
Yeah, the recommendation is to close with some follow-up action, is that to clarify that?
in this case manager's understanding that closure letters are issued,
Okay,
and that in this case, they would be reminded of the surveyor's mandate to communicate time.
okay, thank you.
I think that some remedial counseling about the requirements of the RCW are a larger issue that should be addressed with this licensee above and beyond the need for expedient communication. Is there any discussion of that?
It's actually, 332.
Oh, it's what? Sorry. Thank you. Yeah.
332-130 is what he needs to be. I believe there should be some remedial counseling with that.
Would we like the case manager to consider adding that to their report?
It is actually written, and the case manager's report does say that in addition to remedial counseling, closed in addition to remedial counseling.
Okay, I'm sorry, I didn't hear that. I heard
No, yeah,
counseling about communication, but not about.
it just says remedial counseling, but
That can be included in the counseling,
yes,
that's the comment, right?
Okay, and that will take place by our deputy director. Any further discussion about this case? All right, all those in favor of the motion to close case 2024-05 1071 00 LSV, please say aye.
Aye.
Opposed?
I'll abstain also.
Case manager and Jim abstain. So still passed. All right, case closed. Any other cases, Jill?
So, Ms. Chair, there is none.
Thank you, Mike. Thank you, Doug, for clearing those, putting the effort into them in the last couple months to get those done. Appreciate it. All right, moving on to item 3.2, disciplinary report. Jill?
Here is our pie chart report and our standard report that has been always included and will continue to be included. And then I don't know if anyone's got any questions about this one specifically. This is just a general cases that are open and where they're at.
Including the 6 that we just,
Right,
Yeah.
and 13 will come off of it because there's 7 other administrative closures.
administrative closures
Yeah.
that have been approved for closure. Great,
Right, yes,
fabulous. Right,
okay.
So I have a question. So we have 5 in legal.
Right,
So how did the timing of those occur? Because, I don't know if they're statement of charges or what is going on.
The next,
So do they spread them out in case there's hearings?
well, we try to, yes, and so they're either in the process of under review with the AAG or their statement of charges have been drafted or mailed, so there's different stages at that level, but yes, we try to, space them out so the board doesn't have to have back-to-back hearings, because we do have to offer them like a prompt hearing.
So we get to the point where they're in legal and they may stay there for a while, trying to get the cases.
They may stay a little longer because there's so many.
Right.
And I draft those and, yeah, and unfortunately then our AAG, has to review those. And, we're not her only client, so sometimes I think their turnaround is 30 days is what they expect their review to take. It does not usually take that long, but I mean,
So we may
they're,
get a backup with more cases that go to legal. They'll be accumulating and the legal process may drag out some time.
they take a little longer than, yes, correct. Just because a number of them that are in the. Is that it? Any other questions? Sure.
looks good. Thanks.
Thank you. So this was my attempt to try to get down into a timeline. I don't know if everybody had a chance to look this over, how they felt, if it looked, and if there's any suggested changes. It was just a first attempt.
I don't believe you should put the case manager's name on there because that becomes public right there. And I've had problems with the complainant contacting me. So I don't know if we need the case manager.
Well, yeah,
Maybe that would be an aspect. Right now, it's already too.
Yeah. it's
Yeah.
Late now, but
Yeah.
probably.
Okay. And this report, things have changed since this report was generated also. There's been other, movement.
So when they're in legal, does that mean we're waiting for our AAG to help write up the statement of charges, or we're waiting for a response from the respondent, or what's the?
It could be, waiting for me to draft them up, waiting for the AAG review, or waiting for the respondent. Or even we have a response and going through the final stages of like settlement or hearing.
Jill was trying to add that into the last column under notes.
Okay, thank you.
Can I make a suggestion, Jim? What is it we took the case number off? Because we don't need the case number for this. What we're trying to do is tell you where all of our cases are sitting, not specifically.
Sure, it's just not a connection between case number. and
Yes,
case
can we
manager.
take the case number off this report for public?
Well,
Well,
the
I-
case number is kind of like, it's when we got them. Like, so that's really kind of when it started, like the year, the month.
Can we
Just
just
put the
take
date
the
there.
last number and just
I
leave
guess we
the
could.
2022-06?
Doesn't that identify each individual?
Just by name,
Yeah.
just by case number, I mean,
Well,
I don't, why leave the case number off? I'm sorry.
well, that way we can track, what we're trying to do is have an accumulation of where cases are, who's the next responsible person for the next step, right? And try to keep us all in check of where we're at. I agree with Jim, having the case number and the case manager assigned to it does open the door for people to connect and maybe go talk to the case manager directly about a specific case. We don't need a specific case number for this tracking purposes. You may need it for other purposes, but for the public document, we're just looking at the whole case management, the whole program.
I would think it would be hard for Jill to add the right notes if the case number was not on there.
Well-
But I was agree with taking the case manager's name off. So we're tracking the cases and we can always say, hey, is the case manager overloaded? Do we need to do something?
My suggestion is that Jill get this together exactly the way it is, but before it goes to Mackenzie to go in the packet, we just redact the last digits of the case number. So it's just the year and the month that's shown. And that's it.
Okay, Aaron?
I'm on the other side of that. I would prefer to see the case number, current status, date moved to current status assigned to, drop the case manager and include the notes from the standpoint of if this is a public facing document, the case number is always the guiding number. The public sees it, the respondent sees it, the complainant sees it. Everybody sees the case number. The case manager, they know what cases that they have. This is not for internal facing, this is external facing. The previous slide has the number of cases that case manager has. So the whether that case manager is burdened or not is reflected in the preceding slide. So I am of the opinion that drop the case manager's name. It's not of value to this slide as to where that case is in process.
Further comment?
Or because there's sensitive information here, could this be a closed session topics? We're not making any decisions. It's just information.
It's still a public record, so somebody could, you don't have to put it out as, in your packet. But if they, if somebody requests everything that has to do with the case.
Well, sure.
After
This
the
is
investigation.
a summary of all the cases. Anybody can ask.
Because this is a part of the investigation, so during the investigation, they can ask for everything that has to do with their case, but you don't have to provide them with like a case manager's report, but this will be one of those documents that is related because it shows who's got what. There's nothing here that are, yeah, it's just a document.
Except like the first one, right? It's got a case number, it's got my name, and it's being reviewed by the AAJ. Now, that person with that case number would be saying, oh, my case is going to a possible statement of charges. I didn't know that.
Yes,
Yeah.
they get notified that through our tracking system.
Before it's a statement of charges?
When they get notified at what stage it's in, and one of the stages is under review with AAG, legal under review with AAG.
So they know where.
So they would know, yeah. That's that automatic update with our tracking system. The case manager's name's not on that, but
So like once, now this is produced, right? Nothing you can do about it. It's here, you
Right.
can't destroy it. It's a public record.
Right,
so
just-
you can ask for it.
I've
I'm
had
not saying.
not just one person, but multiple people find out that I'm the case manager, assume I am, and try to call me and talk to me about the case.
Then you just say, no, I can't talk about
Of
it.
course, but sometimes they use a false name.
It's false to talk to you about a case, just say, I can't speak about it.
That's true, but who wants that phone call?
One other question that I have for this report, definition of management review versus admin review.
mhm. Management review is case managers, admin review is Chris or Ken, staff review. Like those are the ones that close it administratively, could close administratively. They're reviewed first before, and then the administrative reviewer determines whether it can close or it should go to a case manager for further review.
So, but it's still within the investigative stage.
Correct. Well, yeah,
Yeah, I'm just trying to understand the differences between the current status, the management review. If it's in an investigation within our workflow, then just put investigation.
yeah, that's why I kind of like put like, so like the notes, like one of them is says management review, but additional investigation is
Yeah.
continuing. So I try to put that in the notes, so, you know, reflect like, yeah, it is being reviewed, but more information is being requested. So, do you want me to change it to case manager review? I can say that instead of management review.
I would rather keep it simple and say if it's
Clear.
investigation, it's investigation. If it's illegal, it's legal. If it's admin review, which is outside of the, you know, investigation stage, so it should be
So you want me to move, like, just move it back to investigation?
investigation.
Can we reconsider talking about this again for the purpose of it some other time? Think that we're complicating a lot of things. And the reason for this report is to help us keep track of where things are at. And so by narrowing it down into it becomes worthless. And a lot of reason why we put it together. So if we have maybe set this aside, we'll not produce this report this way until we've got it resolved with board members.
So where does it go to get resolved? You want it to go to a committee? To the PC committee?
I think that's where we were talking about it before, right, of this report coming out. It's the whole investigative process.
All right. So for future reporting, it's not going to be done until the PC has come up with the report layout. Okay.
One comment on the content though, is the move to current status, January 30th, kind of stands out as being one that's lingering. Is there any update on why that's taking a while?
Yes, we're waiting for action from the respondent, and
How long do we wait?
well, it was a complicated situation. It wasn't just something easily fixed. It was something that had to take time on that respondent's part and the permitting department's part, so it's, yeah,
So no particular concern, it's a complicated.
right,
Okay,
it's, right. it's-
They've been good about communicating with us
Yes.
throughout the process.
okay.
And it's adjacent to tribal land, so they're working with the tribe. So there's a lot of moving parts there, but they're making progress.
Good, thank you.
Sure, I'll have some action.
Oh, good. Okay. You're gonna have that anyway. All right, any other comments on the disciplinary reports? All right. We are now moving into committee reports. 4.1 Executive Committee. The Executive Committee met virtually and in the board's office on August 1st at 8 a.m. Present was myself, Doug and Dave, support staff, Shannon, Ken, Chris, Mackenzie, Greg, Jill, Lana, Bryce, Ian Shelley, our senior financial consultant, and Elizabeth, our AAG advisor. We first discussed the committee chair expectations, which are to resolve our financial plans to make sure that we have stability coming in the future. We'll talk more about plans. Secondly, to approve some of our state examination upgrades, such as the policy that the exam committee looked at, and to work towards getting the LMS, which I can't even remember what that stands for.
Learning management system.
Thank you. Okay, to resolve the UK MRA issues that are ongoing. So we started working on initially the financial report, which is in your packet, where Ian discussed the June financial reports and indicated at that time that we didn't have all the expenses reported from Department of Licensing, and that his, in the report, but that what he reported to us was that we are slightly under in revenue compared to expenses for June. Yeah. All right, and that we had expenses of 181,000 in June alone, and we had a revenue of 161,000. But we are still looking to be on track for the biennium to have, I have it written down here. We have a positive balance at the end of the biennium. 2023. But that going forward, we discussed this at a previous meeting, that it appears that our revenues are not following the projections for the future, and that our licensing renewals are dropping off, but our expenses are increasing, and that we are going to be looking for adding staff, a staff member to work with Jill as she works towards retirement, getting transitioned easily, and a staff member to help expand the state exam process using the learning management system. So those are some added costs in addition to just basic increases. And so Ian, who I believe will come on later.
Yeah.
He's going to come on with the director's report and just help explain some of the scenarios that he ran, that he went through with the executive committee to show the increased our licensing fees, that we can maintain a budget, and we want to maintain a fund balance of somewhere around $1 million but previously it's been kind of between 700,000 to 1.2 million. So that we have, not only a balance to cover any kind of unexpected conditions that might come up, but also if we have a security breach in either of our state exams, that we have the ability to cover that. So we're shooting for somewhere in that 700 to 1.2 million based on, he's just making estimates to see how that increase is going to affect those balances. So we'll look at that later with the director's report. And also just for information, we have not increased our fees for licensees since so it's 2000.
2002, I think.
22 years. 22 years it's been since we've had any kind of increase, so feel okay with saying that we're gonna need to do that for inflation or no other reason, so. That's the fee increase. Oh, here he is. Okay, it's a 10% increase in renewal fees. Will help cover any kind of expectation we have of differences in the inflation results and other variables. All right, so as part of that process, Shannon spent time looking at our WAC. It's interesting how I don't have exactly what I think I'm going to read when I. Our WACs concerning fees and renewal fees. So 196.
26A.
Thank you, 6A through 30. And so when our new business, we'll look at the language that she's proposing. And we have two options for the board to consider. One option is to, in essence, just change the renewal fees and leave it at that. And the other option is to do some cleanup and to combine the on-site fees into the sections that cover engineering and surveying, because there's a lot of repeated language. And one of the things that I learned at the executive committee meeting was that on-site was kind of added to the board's responsibility by the Department of Licensing. How many years ago, Shannon? 24. 24. And so the language was already in RCWs and WACs, and then it was just assigned to the engineer and surveyors board to manage the on-sites. And so that's why we have some kind of repetitive language and different laws and rules. So that was interesting to me, that that's why they're kind of carried outside. So Shannon has done some work to try to clean that up, look at that under new business, along with the proposed fees. All right. The executive committee will be recommending to the board for approval of the amended renewal fees that are rounded up from this 10%. Oh, one more thing first. Ian looked at the fact that our application costs for all of the applications for our disciplines is around 10% of our revenue as compared to renewal fees. And so staff looked at the fact that changing application costs was a much larger process. I mean, we're talking about changes in the Polaris software, changes in applications and other things. And that for that 10% increase was really not as relevant as just this increase in the renewals. So the executive committee is recommending to the board to approve amended renewal fees of $128 for engineers, land surveyors, on-site system designers and inspectors, and that's up from $116. A late fee of $64, and a increase in the certifications for corporations and LLCs of 121. Questions?
Increase to. Position.
121. Okay.
Sorry. Rich,
Yes.
are you asking for questions on this topic or do you want to wait until the end?
No, I'm just reporting.
Okay.
And then we will have that under new business, so we will discuss some questions that you have under new business. Greg reported out on communications and outreach and says that the staff is working to complete the last steps of updating our website and that the new website should be released September 1st.
Yes.
Yay! And it looks good. I got the beta test. Director's report, Chris discussed the new staff positions that I just mentioned. And effective September 1st, licensing staff are being reallocated to professional licensing representatives 1. And an investigator 4 position which is Jill's position, will be double filled so that we have overlap. And a management analysis 4 positions being created and advertised to have help with the exam preparations. We had current action, well, no further action items at this point. And strategic planning items we didn't get to. We had a rather long meeting because of the fee increase and budgeting issues. So that is the executive committee meeting report. And I believe we now don't approve reports from committee chairs, right? We just accept them. And so I accept my report.
I mean, you just submitted it, so that's
Yeah.
it.
Yeah.
It's submitted.
Anybody have any questions right at the moment, other than the fee increase, which we'll discuss later? Aaron?
As a matter of process, is there a way or a better way that we can have the committee reports within either share, where we can, as you're reading them verbally, we can actually see, once every,
I think that's a fantastic idea.
Yeah.
The problem with being able to do that is that sometimes they're produced the night before the board meeting.
and so rather than trying to get them out to relog, if we just posted them somewhere like in a committee reports of the meeting.
Yeah.
They
They're
are
in your folders.
They're
In the folders and the.
of each committee, so you just have to navigate to each
Exactly.
committee to
And
review
that's
it.
what I'm saying, is there a better way we can just drop them all in so we can just easily.
So by meeting date, have a folder that is the committee reports, that is all of the committee reports.
We can look at a way
They're
to
all in one folder.
have that available before.
That would be, okay. All right, hearing no further questions about the executive committee, let's move on to the structural committee, and that's Dave.
Thank you. Structural committee met August 1st at 10 a.m. It's a combined teams meeting with Olympia office in person location. All committee members were present. That's me, Marjorie, and Chen Lau, who's also a pro tem board member. Sports staff present: Ken, Lana, Shannon, Elizabeth, Greg, Bryce, and me. Our first discussion topic was the UKMRA and how it applies in higher seismic regions. The committee provided a quick overview of the FCWS UKMRI to Pro 10 member China. Our next discussion topic was a review of the structural engineer registration application. Committee reviewed the current structural application and will be making updates. There's one provided an initial set of comments for the application for others to begin reviewing. The intent is to provide clarity for the information we want to receive from the applicants and their verifiers. Was an action item. Shannon will review the California, Oregon, and Utah SE applications to use as reference in the questions that are used in their licensure applications. Our next discussion topic was the review of RCW 18.43.020 definition of significant structures. Particularly discussed was item 12C, structures exceeding 100 feet in height above average ground level. The discussion revolved around whether this includes cell towers. John provided some historical information when the determination was made to add the language to the RCW. Our last discussion topic was seismic experience for the structural focus PE. The committee discussed the lack of testing for seismic regions in Washington State in the PE civil structural exam. We are requesting the board to consider the supplemental California PE seismic exam for those applications who are applying for the PE civil structural. There were 3 action items to this topic. First being our request to have a board recommendation to the appropriate committee to review the California seismic examination. The other was for Marjorie to send PE civil practice exam and the California SE exam specifications to committee, to the SE committee. And then the last action item was for staff to send the FCWS exam results to the SE committee. That's the end of my report.
Questions?
Do the cell towers require? The question was, the cell towers included in significant structure that they're over? Are they?
Yes,
Yes. Okay.
if they are 101 feet, then you have to have an SE stand.
Are they always, I mean, are they typically that tall?
Well, they could be all sorts of things. They could be on buildings. That has always been a question we've been asked too, is if they're on a building. Does that work?
Right. Right.
So as part of your report, you are asking the board to make a recommendation to look into adding the California seismic exam for PE civil structurals and relate that to a committee to study.
That's
Is
correct.
that correct?
Yes.
Do you have a recommended committee that you would like to have study that?
I was told it would likely be the EQ.
Okay, so the exam qualifications committee would take on that responsibility to study that further with your assistance. You're not on that committee, and neither am I, right? So if a topic comes up, they can ask for your assistance.
Sure. Yeah.
On that. So if we receive the committee chair's report, then I'm assuming that the board is in agreement to move that to the exam committee for study.
I think the chair has the. So.
Okay. When I receive that report, I will move that to the
Okay, Mike?
Ms. Chair, just a question, on behalf of the EQ committee. Is there some specificity from the structural committee and from Dave about specifically what you're asking the EQ committee to study? And I ask mainly because, as was inferred earlier, there are no structural engineers currently on the EQ committee. So if studying the California seismic examination for potential application in the state of Washington involves technical assessment as it relates to structural engineering licenses, I do believe that the EQ committee would need significant assistance from one of the structural technical experts on the board.
Yeah, Mike, that's not really the request.
Okay.
The request would be the ramifications of administering a supplemental exam, regardless of content or adequacy of content. It's what does it mean
Okay.
for this board if we decide that we want to continue to pursue that.
Okay, 10-4. So logistics and ramifications, et cetera.
And if the board's in agreement that this is okay to pursue, I think the structural committee will refine the recommendations to help explain why we think that this might be a benefit to the state and what some of those ramifications that we can see.
10-4. Thank you.
Any further discussion on the structural committee report? All right, survey committee?
The survey committee met August 5th. Seems crazy. 9 a.m. Members present, myself, committee chair, Jim Wengler, Doug Hendrickson, support staff, Chris, Shannon, Jill, Bryce, Kinsey, Vonna, Ken, with Elizabeth, our AAG. Guest present were Tom Barger, Dave Eisenhower, Pat Beeler, and Matt Rasmussen. Tom is the liaison to the professional affairs organization. Dave and Pat are from DNR, and Matt was on as self public member. Called to order at 9 a.m. Discussion of the committee's yearly expectation and goals. We discussed PDHs, the PLS state exam with a project update. And then selecting or asking, inviting subject matter experts. And then we had a follow-up discussion on survey maps and information as provided to jurisdictions. The discussion topics or detailed discussions were certainly drafting the committee expectations. Staff will add 2 proposed items to the expectations kind of list. Chris and Jill presented a table breakdown of PDH credits per category, comments from the group. The committee members decided to separate a portion of one of the items and create a new item within that PDH, and that's all in referenced in WAC 196.16.120 titled units. Committee will present those proposed changes today. And if the board approves or once approved, then staff will move into a CR 102 because the CR 101 has already been filed. Chris gave an updated update on the progress of the beta testing process with the two new state survey exam forms. She provided an update on that. We had very low turnout expected. And so those beta testing sessions were canceled. And so there's going to be some follow-up questions to our psychometrician to get their advice or recommendation when we have such a low turnout of beta testers. There's also a discussion about inviting subject matter experts to attend and be involved in the survey committee. Committee members agreed that engaging the profession regularly would be helpful in getting input and also garner interest in board membership when survey positions become vacant. And so, Tom Harder volunteered to contact LTW to get an item on the agenda at the upcoming Lead Surveyor Association of Washington Board of Directors meeting next week, and board member Jim Wagner will be available to speak at that meeting. There's a follow-up discussion about survey map data, namely existing conditions or topo map data being used by other professionals, engineers, architects, when as a package within a plan set that's presented to the jurisdiction. That was discussed early on in the April survey committee meeting as well. And then also discussion, or the results were a discussion included ways to engage in conversations with other boards about this matter. Strategic planning items, determine pathways of state PLS exam, and of course work with DNR on proposed update of RCW 5809. Those discussions were not had within this meeting, but they still continue to be on our strategic plan focus. Action items out of this committee, there were 6 of them. One being Chris will update the committee expectations and send copies to the committee members. Chris and Shannon will talk to Dennis about their recommendations of the psychometrician when we don't have adequate numbers of beta testers. Chris and Jill will look at the PDH requirements of other states. See, might seek a little bit of clarification on this because that had already been done. Shannon and Chris will prepare proposed changes. And I believe that this has been done with the comments that came out of the committee with WAC 19616 120 with the anticipation of the CR 102 process or the filing of the 102 pending the board's actions today. Staff will look at other sections of the WAC 18616 concerning PDH units for any additional changes or updates to be proposed. And then staff will review other RCWs and WACs for any contradictions involving PDH units. Namely, we had a little nuance come up with regard to calendar year versus renewal year and just terminology. So we'll be looking at that as well. Meeting adjourned at 11:02 a.m. Lively.
It just felt like PM.
I paused there because the report says 11:02 p.m.
It's fixed now.
Also, surveys tend to be lengthy, I don't believe that we did that.
Thank you. Anyone have questions for Aaron on the survey committee report? Okay, thank you, it's received. 4.4 Exam Qualifications Committee. Mike, are you reporting?
Yes, ma'am, I am. The EQ committee met on August 5th, virtually and in person at the board office at 2:30 p.m. All committee members were present, including myself, Jim Wengler, and Maureen Jackson. Support staff that were present included Ken Fuller and Chris Horton, director and deputy director, respectively, Vonna Kramer, the licensing lead, Shannon Gillespie, regulatory program manager, and our consulting AAG, Elizabeth Lagerberg. We discussed 4 topics, the first being decoupling, and again, specifically the decoupling of final licensure examination, in other words, the PE and PLS exam, from experiential requirements. This is a topic that the board overall has discussed previously, so I believe most, if not all of us, are familiar with it. We identified several potential benefits of decoupling. Those included the increased flexibility for candidates for licensure and potential alignment with national trends. In other words, as far as flexibility is concerned, as we all know, this decoupling has happened in other jurisdictions already, and the decoupling in combination with the advent and, I dare say, ubiquitous use of computer-based testing has led to candidates for licensure in the state of Washington taking their PE examination, I'll use my air quotes here, quote unquote, in other states while physically sitting in the state of Washington. But because we don't currently technically allow that, and no communication has been provided about that to our constituency, people who are doing that are doing it, I believe, just based on word of mouth between each other, having that as an option. And so there's a lack of flexibility for people who maybe are not in the right, quote unquote, social circles to understand that that is an option for them. We discussed that if we want to decouple, then there will be required changes to the RCWs and WACs in order to accommodate that. They currently do not accommodate decoupling of experience from examinations. We considered that there is value to Washington applicants, and we focused again on providing access to the same opportunity to all applicants, as well as how it could streamline the licensing process overall. And then at the board chair's request, we evaluated and discussed the potential impact to the board's reputation, thinking about it both in a positive and a negative light. On the positive side, we believe that because this has already essentially happened because of the combination of computer-based testing and other jurisdictions being decoupled, that we could be considered in a negative light and backwards, so to speak, if we did not decouple fully and allow our potential licensees the same flexibility as other jurisdictions, or the same flexibility as folks who have kind of found this end around regarding our policies. In addition, as was pointed out by Elizabeth, technically our RCWs and WACs do not allow this, and we're essentially looking the other way at present time for those that go this decoupled route through another state. As far as negative aspects with decoupling, the one that we discussed was whether acceptance of decoupling by our board in our state would lead to some sort of reputational negativity on our part from our constituents or the public, that somehow the requirements for licensure as a professional engineer or a professional land surveyor were being watered down or decreased by allowing folks to take the professional examination without experience. We also discussed the fact that if the examinations are intended to test experience of those professionals as well as their education, then taking the exams prior to having what is now the requisite number of years of experience should lead to, if the exams are properly formatted, should lead to a reduced passing rate of those applicants who take those exams prior to that experience. At present, it's our understanding, based on our prior discussions at the board level with NCWS representatives, that there is no data to support or deny that. Therefore, after all that discussion, it will be the recommendation from the committee to the board to move forward with decoupling of the PE and PLS exams from experiential requirements in the state of Washington.
So if I go through kind of just Vaughn and I worked on reviewing some of the other states and what types of decoupling have been done with other states.
We also have a new business item about the approval, and maybe that would be
Sounds good.
more current for us.
Yes.
If you cover it then.
Yeah.
Yeah, thanks. Mike?
Okay, I guess any other questions on decoupling and the discussions there before I move on to other topics?
We will be discussing it under new business again in 5.4. So if you have a question about his report, please ask it. If you want to discuss decoupling, let's do it later.
I would like to ask a question on the report. And is some of your choices of words, for example, as your committee reviewed it, you said without experience as you pursue early examination. But our state clearly identifies that their educational term is experience. And we credit that. So you're really talking about maybe half of what our 8-year experience requirement. So you're not the field experience. So I just wanted to make sure the committee was not going way being understanding terminology.
We will make that clear if we approve for them to proceed with this evaluation.
Correct. And Doug, my apologies if my language choice implied zero experience. My intent was to say the requisite experience as is currently stated by the RCW and WAC.
Jim?
Oh, just a statement. However, we do not require education for PLS or PE, so it could be zero experience. Take the test anyway.
So when we discuss this, we'll talk about the requirement for us producing some attestations that go on the NCEES website as to what we will and will not allow. And some states do not decouple PLS. They do decouple PE. So there's a lot of options we can discuss at that point. All right, Mike, let's proceed on.
Thank you, Marjorie. The second item that we discussed was the draft exam policy. As noted in the agenda for the board here, the intent was to push that forward for final approval. On review and discussion by the committee decided that There are still some finer edits and adjustments that are required before we recommend final approval of that draft examination policy. The committee is going to, especially in Jim's case, have one more opportunity to review and provide edits and adjustments to the policy. And we expect by the next board meeting, we hope to have a final exam policy for board approval. We also discussed NCAAS records and how they relate to licensure application in our state. There was a request for us to discuss and consider potentially only allowing licensure application with an NCAAS record. We discussed and determined that while the NCAAS record is a preferable component of licensure application, as it makes the process easier for both the applicant and for board staff, that at this time, we don't believe that we would recommend making it the only pathway, and that there still be an allowance for applicants to apply for licensure without having an NCAAS record. However, we do believe that communication to our constituency about the benefits of creating an NCAAS record and using it as a part of their submission for licensure should be done. And I have an action item to write an article for the board journal discussing the NCAAS record, the process for it, and the benefits of it insofar as licensure in our state. Lastly, we discussed potentially having the EQ committee review a portion of PE and PLS applications for final review. It was noted that the SE committee has started doing this. I could be wrong, but to my knowledge, I believe that this started last year. And the structural committee noted the benefits of doing that, both for staff as well as for themselves and their own edification. We believe, based on that discussion, that there is benefit similar to the structural applications and the structural committee for that review. We noted that there are many more PE and PLS applications than there are SE applications, and it would be infeasible for the committee as it's currently staffed to review all of those applications. We discussed how many would be appropriate, and we arrived at an action item of staff, i.e. Vana, sending one excuse me, apologies, staff sending one application per week to committee members for review, both for the PE and PLS. They would go to the appropriate member. In other words, Jim in this case, or PLS, reviewing a PLS application, and myself and Maureen reviewing the PE application. And then at each committee meeting for this year, 2024, 2025, we would discuss one PE and one PLS application at our committee meeting, if for no other reason, again, to familiarize ourselves with those applications, the process, and typically what's being submitted. I believe that's my report. Are there any questions?
Thank you, Mike. Any questions for Mike? Doug?
I would anticipate that there were some threshold criteria for staff to forward those applications for review. Are there any, or is the EQ anticipating those to be fully random or based on some threshold advancement of question?
That's a good question, Doug. We did discuss that to some extent. I believe where we've landed right now is that opportunity, if there are issues with an application that uh, surpass staff's ability to consider, including Ken and Chris, that those are already forwarded to the EQ committee for review. I believe that this current initiative being discussed is intended to be a somewhat more random selection of PE and PLS applications to send to the committee for review. Again, just for edification of the committee members and extending the dialogue between the committee and staff who are reviewing those applications. In other words, if there are no PE or PLS applications in the staff's judgment that require consideration by the committee, there still would be one application of each forwarded each month for review. Each week, sorry, for review.
Thank you. Thank you. That sounds like, yeah, you're already anticipating any questionable ones being sent to committee, and that any others advanced to the committee for committee members for review are for calibration of the process.
That's a good way of putting it, Doug.
Aaron?
I guess with that same question that Doug had, is it possible, as a friendly request, is it possible to put within the report the number of applications that we're talking about that we get, that the board gets in a specific period of time, to where we know one application per week is a, 1%, is it 10% of the applications? I don't know what the number of applications that we typically get.
I think Vana's reports, with her great little charts, tell you how many applications for every 2-month period, right? Those little blue charts.
Okay, but how does it relate to this? Staff will send one application per week. It's that.
Well, my feeling is the committee is doing this to start the process. And I would hope that after 2 months, the committee will say, hey, I can't keep up with that, or I could do more. But the value that Dave and I have gotten out of it is understanding whether our applications are written in a way that are understandable. And are there anything that we could do to add to that to make it easier for staff to evaluate? So we've also, at some point, promised Vana a list of things to look for in applications. And I'm hoping that this initiative, as Mike described it, will lead us to a place where we can say, okay, these are the really key issues I want to make sure, direct charge of a project, or what are the key issues that we want staff to look at. But without having seen any responses to applications, we don't know if people are understanding us as they should be or not. And so I think that's kind of the process. So it's not so much, hey, let's look at a certain percentage of the applications as much as get a flavor for kind of what they're seeing. I trust Vana to kind of know, oh, this might be a good one to send to somebody, because it kind of shows what I'm used to seeing about how people either misinterpret some of our questions or, so. Does that help, Aaron?
It does. Again, I'm trying to correlate the one application to the final numbers that are on the subsequent slides from staff. Is that a good?
I don't know, I'm looking at the last 6 months. If you're sending one surveyor application a week, that's 100%.
I
Right,
think
but
in
he's,
2 months, the committee can decide to change that. I think it was great to make a decision on how you're proceeding and
And again, forgive me, but my question stemmed from what, if we can have that blurb within the report, at which, within the committee's report, 2 applications were sent to committee members, I don't know, 500. That's it, that's all I was, but I didn't have to go back,
Yeah, that's fun.
okay, so Lana will report that next time.
just,
Dave?
I'm wondering, I think it'd be curious to see what the trends are, if EQ could look at the application relative to the NCAAS exam that they sign up to take. So in other words, as an example, a PE civil spent the first 2 years of their career doing structural work, transitions to geotechnical work for their next 2 years, decides to take the PE geotechnical exam, you know, and then we license them. So they have mixed experience, mixed specific specialties to get their exam. I think it'd be curious to see how much that's happening now that NCAAS has created this new exam structure. And it's not just PE civil, it's PE electrical, PE mechanical. Mike, is that making sense, what I'm saying?
It makes sense what you're saying. I guess, Dave, the question I would have is, are you looking for anecdotal data on that or comprehensive data? Because
I mean, are we
so, I'm
seeing
sorry, say again.
anecdotal at this time? You know, are we seeing that it's an issue that we should pay more attention to? That's all. It's,
Okay.
you know, is it once in a blue moon or wow? Are you seeing applicants that, you know, did geotechnical 1 year, site development the next year, structural work the next year?
Sure.
and again, you couple them. Well, you don't have to have any experience.
Before the exam.
Exactly.
If I may, under our, and this is probably where you're going. Just under our code, once you're a professional engineer, you're a professional engineer, and you work to your skills. So if structural engineer retrains himself to do geotechnical, he doesn't need a new exam under our.
Now, under our current rules.
Now, if they go the other way around and try to do structural on critical structures or whatever, then yes,
Well, it's significant. They can still do structural work.
they can still do structural. But so I'm not sure how we're gonna get data that doesn't have to happen.
I think that I would just like the committee to be aware of this when since they're going to be reviewing the applications, report back, here's what we're seeing. Here's a trend, maybe this is something to consider further, maybe it's not, that's all.
Dave, I think it's easy enough for us to have that in mind when we're reviewing this sample of applications. As Aaron infers, I think we are likely going to be seeing as committee members a relatively small subset of the PE applications, while the percentage of surveying applications that are reviewed are going to be much higher. So in the sense that if all you're looking for is, again, anecdotally, here's what we think we're seeing in the stuff we reviewed, I think that's easy enough to do. If it was our quest to be more comprehensive in terms of the data analysis, that'd be a much heavier lift.
Yeah, no. And maybe Vonna could just keep that in mind too, when you're deciding which ones to forward. It's like, oh, here's an interesting one, you know?
Sure.
I have an expectation that you don't see a significant percentage of come in for a second exam.
Not as significant, no.
It does happen, but.
Does happen. I mean, I know one guy, who's mechanical, took his fire protection. Decade. But.
Yeah, pretty common. Yeah.
But the point is, not too many people are going back in for a second exam. They just develop their experience and capabilities. But we can watch it. That may be an area of emphasis.
Aaron?
So last question I have is, when you're talking applications within the report, you're talking about new applicants. So
Yes.
not company applicants, not,
No, they will,
Really?
comedy and
Oh.
by exam, yeah.
okay,
Anybody that's coming in to get licensed.
okay, all the application process.
Any further questions for Mike for the EQC? All right, thank you, Mike.
You're welcome.
Item 4.5, practice committee, Doug.
Thank you. I will note that there was something we had hoped to do out of the practice committee, but because this is a special board meeting, we're not going to be able to do it. Yeah, we can't add something if we.
Sorry.
That's fine. So we met yesterday. We'll record it. And there's some corollaries. Practice committee met yesterday afternoon at 1:30. 1 hour, including committee members, myself, Mr. Beeden, and Mr. Blaisdell. We had guests, including Mr. Winkler, and all staff present here. And so we had everyone else here. We assessed the complaint administrative closure summaries. You will have seen those again this morning. And the content of the administrative complaints of closures. That's 5 engineering ones. And 7 overall closures. So 5 complaints received, 7 closures. 1 engineering building. We looked at the compliance monitoring report, again, as reported earlier in this meeting. Get 3 on compliance monitoring, Huxell, Berkey, and Morto. There's a repeated content on Mr. Huxell that's present already in your report here that basically says we're still waiting for Mr. Huxell's refiling, as he was charged with the court to do, if he's going to appeal. Do that by the 16th of August. After that, I believe everything just kind of falls down on him, and we'll see what actually happens. Can't worry of any actions. Mr. Berkey and Mr. Borda are both in compliance with their board orders. Mr. Berkey has completed the terms of his as a lieutenant. Mr. Hawkins and Bodge on the non-compliance reports will continue to be held here. Reporting to the PC, the 1843 task force had met, and they were described to public meetings, to public hearings on minor changes and the addition third pro temp to include a on-site septic system design in 1843 and 33. And there were no substantive comments. That's proceeding, and the committee and staff are advancing to essentially the legislative interactions on the recommended RCW changes. The task force has stated would like the PC and now the PC to request the board to give the task force direction on the title use and timing of the actions for 1843. We will have that as an action item and new business for October. We already had, as noted in earlier this morning, discussion in the last meeting minutes. The board has already directed the 1843 task force to work towards title stuff, but it did not yet give timing. So the 1843 task force and PC will continue to look at the content, and motion timing would be.
Why isn't it in our new action? New business agenda, 1943.
This deals with the editorial changes, the obsolescent terms.
How do we know that?
It's
It's an agenda topic.
The new business, well, we have already approved.
New business.
Oh, okay,
Next
next step.
steps for
Right.
RCW 1843.
So are you saying that we will not be able to discuss?
If it's already there, then we're good. Okay, I had not read.
Yeah, okay.
Missed
So
that,
we can
yes.
discuss.
So yes, we could talk about it, but it's gonna deal with the timing.
Yeah.
Because that affects, staff inputs and public interactions for those. So great, I appreciate that clarification. So we'll move forward with that. Discussions were held on the interagency MOU, with WSDOT. This has been the subject of, several board meetings and meetings with these bodies. The DNR and DOT have occurred, and DOT's basically agreed that they're just going to license as appropriately and move forward. The MOU does not exist with them any longer, and DOT will be working with MOR for standards for monument preservation. Complaint process, the question of feedback assessments. So staff reported that assessment questionnaire has gone live. They've only got one response so far, so we'll hold off for the board report. So again, recommendations to the board would be the direction of the task force on next steps, substantial timing for title. The PC has action items to address on their agenda, a checklist for public officials and brainstorming topics. That will be straw man type first list with Jill. And along in some of the discussions, a lot of the discussions lately about to COAs, renewal of COAs. So Greg is gonna facilitate, and I and others are gonna write an article for the journal about the certificate of authorizations, the renewal of such, and whether designees, designated engineers should pay attention, for example, when they leave said company, so that they're no longer identified designated engineer. Or when they become so, such that they know it. Anyway, so we've had several complaints and administrative actions have been dealt with. COAs not being up to date. And those are the action items and recommendations.
Thank you. Anyone have questions for Doug on the practice committee report? All right. It is received. Thank you. Item 4.6, the UK MRA Task Force. We had a task force meeting on July 25th at 2 p.m. virtually and in the board office. Attending was myself, Aaron, Ken, Christina McKenzie, Elizabeth Lagerberger, advising AAG, Greg, Shannon, and Bryce. Our first discussion topic was the legal impacts to professional engineering licensure in Washington. Maureen, are you somewhat familiar with this issue of the United Kingdom and the US looking at a mutual recognition agreement? We talked about that.
I read the information that's attached in the package,
Okay.
but I had not heard of it previously.
All right, so, yeah, not many people have. So NCEES has signed an agreement with the engineering consultancy in the UK. And the essence is if someone has education, 7 years of experience after education, which is more than what we require for a PE, and the examination process for either country to get licensure, that they would go on a register called an international PE. And that therefore there should be some easy comedy between the countries without having to take our licensing exam or us take their licensing exam. And every member board in the country has a right to agree to this MRA or to not accept it and say we don't accept international PEs without going through our standard comedy process. So right now, we require foreign applicants to take the PE exam in their discipline to get licensed. And so that's, in essence, the biggest issue is do they take the PE exam or not? Ms. Lagerberg reviewed the mutual recognition agreement and will be confident there's no necessity to change RCW 1843 to accommodate for the MRA if the board chooses to accept it. Education, experience, and examination requirements described within the MRA are rigorous. And she stated that there's no signatory language that would prohibit the board from signing the MRA, so nothing that's legal in there that we wouldn't be able to sign. She also added that there's termination language within the MRA that says the board may choose to withdraw after 6 months of signing. One could test it and change their minds. Next topic. Did you want to add anything to that?
The topic that's going to come up again.
So we are going to discuss it in new business as to whether the board wants to move one way or another with this. So you want to weigh in
At
then?
that table, and there's really kind of one topic that I.
And you have the table, so
Yeah.
you want to give the, or do we have the table on the board?
I haven't sent it over, so.
You could send it to her to put out if we want to later, just so she has it. All right, so next topic is documentation that the MRA will not apply to structural engineering licensure in Washington. And any other additional requirements, how would we document that? If the board chooses to sign, the task force wants documentation that the board has signed and accepts the MRA. However, that structural engineers, SEs, applicants from the UK would be required to follow the board's current SE application process. We discussed how we would document this, whether it has to be a change in WAC or Elizabeth recommended that a board policy would be probably the best way to address how UK applications are going to be processed in Washington State if we move forward. And the policy could explain that SE licensure is not an option within this pathway. All right, next topic was we asked Aaron and Ken to be aware of what's happening on Western states positions, that we would like to have some commonality between our neighboring states on how we address this issue. Mr. Fuller reported that the Oregon board is not ready to sign and that California has already agreed, with the exception of the SE licensure, just as we just discussed, that that would not be a part of it. Mr. Blaisdell stated that Alaska board will be present at the signing, and which is just a kind of a celebration, and really the signing actually occurring at that point. It's more a matter of we're in a positive mood about the process. So that they will be at the signing in Chicago, and that they will consider each UK application on a case-by-case basis, so they're non-committing. And Dr. Q will present the US-UK MRA issues at the Western Zone meeting at the NCEES annual conference in August. So we have a chance of hearing all of our Western states thinking about this. Mr. Blaisdell believes the MRA will assist our board in forging clearer pathways to licensure and to help reduce barriers. Next topic was discussing considerations for other comedy applications from other foreign countries such as Canada. This has kind of been my platform all along, and I don't want to make an agreement with the UK if we're not clear with our Canadian and Mexican neighbors. So if the board chooses to sign the MRA, it should consider reviewing agreements with other countries. Right now, there are no particular agreements specific to our state, nor with NCEES. However, there is a international engineering registry, which we looked at, called the International Engineering Alliance, that is a registry of many countries. I'm gonna just say 30 countries that participate in this alliance, which has evaluated their licensing program and has said it meets certain standards. I haven't specifically found out what those standards are, nor do I know how often they audit the different countries and their processes. But there is an engineering alliance, and they call their roster, so each country evaluates their own residents and can put them on a roster if they meet these certain requirements, and they're called an international INT. So there was discussion of if we sign this agreement that's specific with the UK, how, what's next? Does this lead to issues with any of the other countries that might come in and say, well, we have a roster of NPs also, and do we know that the same processes are being looked at with these others? So more investigation is needed in terms of the International Engineering Alliance. And, just how this is going to work when we have applicants coming from countries and say, hey, you didn't make that UK guy take a PE exam, so why are you making me take it? So I think those are some of the issues that we need to discuss when we look at this as part of new business. Next topic discussed was the potential for additional examinations and or law review changes. And one of the things that I have brought up previously is that the UK does not use the same building or bridge or design codes and standards that any of the states in the United States uses. And that someone coming in and getting licensed, if they haven't been told to evaluate not only the US codes, but Washington has specific codes for energy requirements and seismic. And so how can we be assured that we're protecting public safety if we license people who may or may not have evaluated those codes? And so one option for that is additional testing. Or just take the PE test, which has a certain amount of code, US code requirements within it. Or another idea was to potentially add something to the law review exam or on our application forms, well, where we're requiring people to attest to a certain level of review or knowledge or experience with codes and standards. And so the task force would like to ask the exam qualifications committee to consider potential changes to our law review exam or to application forms or something, as they're looking at decoupling perhaps this issue of how do people from foreign countries assure us that they will design to our codes and standards. We'd like the exam qualifications committee to look into that. And such as an attestation for applicants to confirm that they've read and understand the Washington state codes and regulations. The structural committee has reported is looking into the issues about seismic, making those recommendations. Action items, Elizabeth to summarize her analysis and present at the board meeting, which she's going to do later. Business. Board chooses to sign the MRA. Ms. Lund will begin reviewing the IEA requirements. So that's the International Engineers Alliance. I don't know about that. Board staff to develop a policy if it moves forward in order to talk about how we're looking at foreign applications. Aaron and Ken to coordinate, collaborate with the other Western states. And the exam qualifications committee to consider looking at the potential changes to law review exam and application forms if the board decides to move ahead. And I gave myself another action item to help develop the attestations regarding local codes and regulations if we have direction. So recommendation to the board, the task committee is recommending to the board to attend and participate in the event that's happening for the signing of the MRA with NCEES member boards, and to agree to develop further a policy explaining how our procedures are going to proceed. It's the end of my report. Questions?
The recommendation was to sign.
The recommendation is to attend and to move forward in understanding how this process, I mean, we still have some issues to consider in terms of other foreign countries. And so it's up to the board to recommend whether this task force continues on and does some study, that the EQC evaluates changes to the law exam or application forms, whether we move forward soon or whether we move forward in a more methodical approach. Dave?
I think it's a good question. I could save it to the new business, but I'm just wondering, you said contacted California. What do they intend to do about their supplemental PE?
Because they're discipline specific, they still will require the engineers to come on, take this state exams.
Okay. But they are excluding seismic like we're
They're excluding SE.
structural.
Right,
They're excluding structural like we're excluding.
That's what I understand.
yes.
Okay.
But their PEs, if they're a civil PE, regardless of whether they're geotech or structural or water resources, they have to take the seismic.
Yeah.
And surveying. I think the surveying is still required for all civil. So. And that is a 2.5-hour exam that California prepares and Guam pays them to give it to their applicants. Aaron?
Follow up on Jim's question, that I think the recommendation is to both attend and sign. Because it was based on the review and the analysis of the AEG that she did not see within the information that she had a conflict in us signing that.
She does not see that we have any language changes that we have to make in order to do that.
But I think the conversation went on from there. It wasn't, I don't think you decided just because of that.
Right.
And my understanding is, as a board, we don't sign it. NCWS is signing this. We just have to bring the board applying it.
It's kind of opt-in as well. You know, it's how I would.
Right, you give NCES a document that says, here's how we're gonna evaluate people who are on that roster because of that agreement that they signed with UK. So it's more about us writing this
Right.
attestation.
And answering the specific
Yeah.
question, what will be on the form, as you type it into NCWS, what does the state of Washington want? And that would be on NCWS's website when they apply.
Right, but the recommendation is to both attend and participate in the signing. It's a signing of it. And whatever we-
We're not signing. We're participating in the fact that NCES is signing an agreement with them. And we are notifying NCES that we are preparing a document. And I am not necessarily in favor of people not taking a PE exam. So just throw that in.
But we should talk about the car. We're not going to talk about that.
We are going to talk about it at 5.5, and also I've invited Ed Houston, who is a structural engineer who has been very active with the UK Structural Engineering Organization, but is also very familiar with IEA and the seating, and he's going to join us at 1:30 to just provide a little information about their process. We can discuss that as we discuss whether we're moving forward one way or another on what we're going to require people to do in terms of licensure. Any other discussion on committee reports? The on-site committee, which is headed by Mike, along with some subject matter experts, did not meet during this 2-month period. So there is no report from them for this time. And it is Minutes early. I say we take a break, and then I've also asked for a lunch break. When I was a boss, I believed that it was very valuable for everybody to get up and do something different during the middle of the day. Go play ping pong, block, talk to somebody about non-engineering or something, clear your head and come back. So I have asked staff to change our process for this meeting and perhaps going forward where we don't necessarily eat during the meeting, that we do a little bit to kind of clear our heads, have a bite to eat, even though it's a rather tight time frame, and that we're all back here in our seats by 12:30. Okay?
Maybe, we should that change.
Where's the ping pong table?
Yeah.
I would note the hotel checkout time if you have it.
What's that?
May want to check out and then brief period that you have.
You have checked.
All right, thanks for hiding. We'll be back at
Not
12:30.
checking back.
Thanks, Mike.
You've got to keep them with us.
Yeah, just to confirm, that's 12:30 that we're coming back on.
Yeah, please.
Okay, thank you.
12:30. Thanks. And real close. You've opened the meeting back up?
Yes.
Yep. Okay, let's start the recording.
We're recording.
Okay, so we are the Board of Registration for Professional Engineers and Land Surveyors, and we're back in session. And we are starting section 5, new business. And it starts with 5.1, approval of the CR 102, which is a rule-making process that we go through whenever we change a WAC. For WAC 196-16-120. And this is from the survey committee. And we have attachments for it.
Right, so on behalf of the survey committee, we are recommending these changes that if you see Act 196-16-120, which is the qualifying activities for PDHs for land surveying. And so the changes really are stemming from the, as the analysis and the results from staff and looking at the PDH audits and times at which we look at the PDH information that's coming in when having complaints, our audit, and just overall stakeholder discussion. So we did really two things, actually three items. Specifically, we looked at the for each hour, number 5, for each hour of attendance at professional and technical society meetings with an informal program, we increased, or we're recommending the increase of the maximum PDHs per year from 5 to now 10, and that with the intent to provide more ways for professionals to get more PDHs through those means of attendance, to get more people to engage and come to those meetings and conferences. Number 6, for each hour of attendance to this board meeting, so this group and committee meetings. And then we increased also that from, it was in, currently it's 7.5, not to exceed per year. We increased that to 10 PDHs per year, again, for the same reason as item number 5, to just get more participation at this group in our committee meetings. Scrolling on down, item number 10, we made so we made the change of for each hour of participation in organized courses, including employer provided courses. Current item number 10 includes first aid safety, along with technical and management skills. We, after discussion, the committee decided to move the first aid and safety out of item number 10 and make it its own item. And that makes item number 10 a more robust employer provided courses, organization of courses. And then we put a maximum of not to exceed 5 PDHs per year for item number 10. And then scrolling down that first aid and safety, we pulled that out, made a new item 15, similar wording, but just the first aid, safety, and security training not to exceed 5 PHs per year. And again, these are all from the results of the audits and or complaint information that's coming in. And meeting with stakeholders, professionals, registrants. So.
I move we advance this to this DR 102 process.
Thank you. Dave moved that we advance this WAC 196-16-120 to the CR 102 process, and Doug seconded it. Is there discussion?
If I may, I think that item 10 differential, the observation across the committee one, both in capping it and in differentiating values. The item 10 was converted to a value more specific to professionalism, whereas the item 15 categorized and created a cap then on things that would be classified as like standard worker practices, general practices.
With a clarification, professionalism, but more practice related to practice.
Yeah.
So the item 15 is like has what we're a lot of those things that are general employee and whatever, rather than dealing with the professional. And so capping that, for example, the as Whopper can be generally classed as an 8-hour annual refresher, a 24-hour and a 40-hour. And so with that at Carriage, the committee felt that was a disproportionate allowance of continuing education credits, which were not relevant to the practice.
Got it. Yeah, that's good.
That's the question.
Yes, Marie.
It looks like item 10 language is slightly different than what I see in the packet. I see in the packet, it says including employer provided courses, period.
You're correct, Maureen. This was actually a very recent addition that I'm showing here.
Okay.
From what was sent out with the packets.
I have one other question. Can we, is it okay? Can we ask?
Yes, yes, please.
So on item 6, I know, Aaron, you said that you intended that this item be for this board and
Right.
meetings and committee meetings. I'm wondering if it should not say the RPLS board. I just wonder if someone coming in would think, well, I'm on the board of some other organization and think that they could use that.
Yeah,
Yep, absolutely.
Just
I
Just
think
add URPLS in front of board.
in the beginning of 196, I think we defined the term board. And I don't know if we define our acronym.
But if it's defined, it probably should be board capital, although I'm big on that one.
It's hard to say.
That's a contract thing, I guess.
So someone could just log in to a board meeting, collect 6 hours of PDHs.
No, 10.
Our meetings.
But they could.
Thank you for your multiple.
The value is we want to get Steve to help out on committees. And so this gives them an opportunity to clarify that they've got PDHs if they're working, listening in, attending. So it's a good step. So what is the decision on four polls versus board?
Well, we would also like to attend the DNR Survey Advisory Board meeting.
Ah,
So that would be an advantage too, but that may fall under.
Number 4 is number
4.
Not
Yeah,
yet,
yeah.
so.
Could we specify?
I'm a little hesitant as committee chair, I'm a little hesitant as to start defining oracles as the BRPLS, because I think that within this section and other sections of 19616, we talk about the board, and that may kind of throw us into we have to start redefining the board into the RPLS.
Yeah.
It
It
is
is in the
present.
definitions.
It's in 105 definitions.
Right, but does that mean that we have to, so just clear on that,
Leave it as written.
right, right, and I think that it follows the intent. And I don't think that we've had, Jill can correct me if I'm wrong, I don't think that we've had PDHs at which registrants have that as something that is really a big item that they do.
Yeah, we saw a minor amount of them claiming this. We want them to be more participatory.
Yeah.
Right. Yeah.
Can I ask about number 1, college hours? Do we define what kind of coursework that would
Well,
include? I mean, does it matter?
fair, without a 4-year college degree program in surveying, that's why it's left so broad. Where
Well, I mean, if I go back and take a Asian art history class, is that need to be a survey related coursework? Does not need to channel.
I guess that would depend. I mean,
Well, I mean, the way it reads now, I guess you would get credit for it, right?
or would you take it to someone and say,
I probably would ask somebody, obviously, yeah.
I think within 18616, 115 about qualifying activities, and then subsequent later it says qualifying or activities not. And not it's sort of, I think it starts to bear that out.
Define that you're trying to get them to increase their knowledge
Yeah.
in the profession.
Trying to make it as broad as possible, but not being so specific, in which there's going to be exceptions.
Any other questions? We have a motion on the table to approve moving WAC 196-16-120 to CR 102. All those in favor, please say aye.
Aye.
Opposed? Okay, motion passes. Thank you, Survey
Thank you.
Committee.
I get some clarification, please, for Jill and I. Would you like us to continue to track audits? I'm assuming. Yes, okay.
Can I get clarification? Are we putting polls in front of anything?
No,
Okay, thank you. So it was fine the way it was.
it's a nice idea, but we've got it defined.
Thank you.
Okay, next from the PC committee, item 5.2. We want to discuss the next steps for RCW 1843. We have an attachment in our packet that is a timeline. You want to talk about it, Doug?
Certainly, the timeline was provided as a refresher of how we ultimately move forward considerations and changes. And at this point, that timeline reflects that the editorial 033 Pro 10 recommendations that were drafted have undergone input as well. And there's been cited 4,400 public comments on other draft considerations of change, right? And so by the direction of the board, proceeded with content to move forward to basically legislative interface and interaction, the 033 and general editorial obsolescence type edits as well. And that is going well, but it's going to take resources of the staff. And as of, for example, I'll get the June minutes, item 5.5 and discussions that we're continuing work on considerations of title. But what the task force wishes is some board direction on timing of advancement for 1843 title proposals.
Okay, having to do with the legislative sessions?
It will certainly have bearing, be borne upon by the legislative sessions, but also our staffing and resources, expectations of public interaction.
But to be clear, though, nothing more for this legislative session.
Right.
Correct.
This would be future.
So the board can work on how we want to address the issue of title of engineer without absorbing staff time, I would assume, to some extent.
Yeah.
While the staff is busy getting the current proposed changes through the legislature. Is that fair to say?
Yes.
I mean, you're going to have a big piece of this push to, I'm assuming we have
We're moving forward.
representatives and.
We will tomorrow.
So the primary question would be that 1843 through PC was, do you wish to set a target of essentially legislative advancement at the trigger level, threshold level, or the title content in completion of the proposals for title content to the threshold of legislative interface and motion in 1 year, 18 months, 24 months?
Well, I
He's
can
playing
make
baseball.
the decision.
So we certainly look for the inputs. Then.
Okay, I understand there are a lot of steps along the way there for a decision to be made as to whether anything happens or not. Right? You don't need to change anything necessarily. That's part of your decision. Right? So if we say, okay, I want it all the way through stakeholder meetings by September of 25, I mean, the first step's got to happen as to, you know, how do we justify whatever movement we make, whether it's proceeding with a change within the RCW or not? And I'm looking for why aren't we talking about what each of those steps are along the way and how you're going to make the first step, rather than saying, well, when do you want us to be done with all of it? Well, if you say the definition of engineer is clear in our RCW, then that's it. Right? And I want that decision soon rather than next September. So,
It's what we
If
had.
I could,
was Jim first?
sorry. I raised my hand.
You too. Was it back at that? I thought we had come up with the language, approved the language, and just waited on timing. So is that not through that? That's why it has to get this timeline. So I did that.
Yeah, if I can answer that basically, and this is going to be kind of an overarching answer, so I apologize for it. For us to do anything with the title engineer that's going to restrict any government agency from the use of their current regime of the title engineer, we're dead in the water as a proposal from us as an agency. Because the governor's, there's no way it's going to go. It would have to be an association-driven proposal. And then we have to back away because we can't be grassroots. So if we were to go down the title act that you guys propose, right? Working through it and saying if you're civil, mechanical, electrical, chemical, environmental engineer, you have to be a licensed PE because that was the proposed language.
No, I
Well, wait a
do
minute.
not think we approved any kind
Let me just finish that overarching comment. I apologize for being disruptive and rude. But if we go that direction, that's going to be dead in the water. So if somewhere behind that, we don't have clear directions. If anything that the board talked about as a title, that question, other than back at the beginning of working on the practice of engineering statement in 1843-25.
Sorry.
to interrupt, yeah. We had proposed in December a selection of things we could do, and the only ones we agreed on was to move forward what we have now completed and I'm putting in front of the legislature. We had options to clarify that we can't define the term engineer, that it's generic. Elizabeth had pulled a bunch of language at one time, partly I think from California law, but also saying, you know, we can't adjudicate that title. We also looked at, like you said, defining and saying nobody can use these titles of these certain branches of engineering. We looked at, you know, going 100% and saying, okay, nobody calls themselves an engineer unless they have a license, which we know from Oregon having been sued over that we can't do that. That's pretty clear cut. Can't go down that path. But we never picked a direction. And I guess what I am asking the PC to do now is go back to that list of choices, scratch any that you don't believe are something that can move forward, come up with some options for the board to look at, because we can't sit here in a board meeting and say, just find some language to put in RCW that says we can.
So I would like to propose that the BC 1843 task force be assigned to those draft proposals, resolution by draft, advance of proposals by April.
So that's page S. By April?
Yes, by April meeting,
The
not the
language,
public interface, nothing, but
the language,
but
or not.
the proposed language.
I would like, I mean, my personal preference is for you to say, this is what can't be done. This is what can be done and why we think it's a good idea before you come up with specific language on those different areas and spend 9 months preparing language that we choose from at that point. I mean, let's take it in steps.
In that case, Madam Chair, PC has no further motion.
I think we should have a discussion, if we should just even pursue this at all, the whole board, because we keep on going back and forth to EQ, practice here, and that's why we keep on bringing it back to the whole board. What does the entire board want to do with the title engineer? Want to just leave it as it is?
Something or nothing.
Something
Yeah,
or not?
something or nothing is a really good start.
And in addition, we may have to deal with 1843 with decoupling. So that's another one that's kind of, what's more important? Is this broken right now? The case has run its course. And where are we at? It's fine. The court said it's fine the way the language is now.
I don't, the
Because-
court ruling was not really about the language. The court ruling was about the standing fisheries.
Right, but ultimately, he wanted us to not allow people with the title engineer to use it.
And the court said, you don't have the right to ask us to do that.
And nobody else has come up with, that has the right to ask the question, so it was dead.
But you've had this survey.
We did
Put
have
out a survey.
questionnaire.
The questionnaire, the licensees, not the public.
Yes. So,
Dave had his hand up.
Well, thank you for, I was just gonna remind everyone that we did vote the hornet's nest with the questionnaire. And there are a lot of people wondering what we're going to do next. So I think the do nothing might not be well received.
I think do nothing would have to come with a clear explanation about why we feel the definitions as written in 1843 are appropriate for how they define engineer as used in the chapter.
So one more question, who could best succinctly summarize the sense we got from the survey questionnaire? What is there? I mean, 4,400 plus responses.
Yeah, Ken and I went through and tagged every single one of the 440, you're saying, 4,400. 4,400 responses.
Yeah.
And we felt like saying something about, whether somebody should be allowed to use the title or not. And so I can work with the task force to pull back up that summary and say, but it is a piece of information that is just real multidimensional, but we asked a specific question and we got this broad range of comments by people. And so we feel a need to sort of address, thank you for your comments, but engineer is defined this way. I mean, at least it's going to be something on our website that says why we believe it is okay as it is. Or we write some clarification that maybe goes through when we're decoupling.
I think though, from our legal perspective, it's really kind of not okay the way it is, just because there's ambiguity there. So for a long time, we've been talking about, maybe we should just fix that little ambiguity.
Yeah. 2 words, the profession.
Yeah,
Front.
right. Something's very simple, which is basically not doing anything with respect to title. It's only fixing the ambiguity, fixing the definition so that it's just,
And
we don't have this thing that we can get more people filing suit.
And we get solid support from the governor's office for that because they don't want to risk going to a lawsuit that impacts 40,000 jobs in the state.
Is it possible to get someone who has maybe no knowledge of kind of our history to look at that language and say, you know, what does it mean the way it's written and how to make it clearer? I mean, can we get a third party that's,
I mean, we can ask for an AGO opinion, the board can ask for an AGO opinion. I think what the AGO opinion will be is that it's a gray area, it could be interpreted this way or it could be interpreted this way. They're not gonna tell you how to fix it. They're just gonna tell you, you know, if you interpret it this way, this is what's gonna happen, but you know, that's like what.
Wouldn't a Superior Court judge's opinion be an expert, an unbiased opinion that found that language meant? And kicked out
first opinion?
the first, not the first one, but the second one, after we went back. And then that's what gave us the.
No, but I'll tell you why. I mean, it definitely shows because you have two different opinions that came up with two different things from the judges. It definitely shows that this is an amendment, and it's capable of different interpretations. And frequently, the AGO will, you know, say, here's one way, here's another way, here's what, you know, I, as myself, here's my opinion, but it won't necessarily be, this is a definitive answer. So, and those two different opinions from the two different judges have no legal effect.
Right.
They're just showing you that people have interpreted.
People that are at a higher level than just whatever, I mean, these are experts at sea, right?
They're judges, so their job is to interpret the law.
Yeah. So I would think that would be enough weight in itself to say there's a problem.
If the board was to move forward with simple language changes that improves the clarification, would you be willing to work with the task force?
Yeah, we could get
To do a simple clarification?
on board just to, you know, make sure that
Really close.
from her perspective, but, you know, I think we proposed to in the past, like a very simple way to fix. But then it's not, I just want to make clear, that's just fixing an ambiguity. It's not making any decision one way or the other about what you actually want to happen. It's just.
Right, and so then we would need to notify the public in some way or another that the board feels this is the direction that this goes. Aaron?
And with regard to the engineering title subject, we are, since 2022, we are talking, putting professional in front of engineer and professional in front of surveyor or land surveyor.
One
Correct.
way to fix the chapter is to go through adding the word professional. The other way to fix it is to improve on the way the definition is written, that term engineer and the term land surveyor are used as shorthand basically in this chapter.
Right.
Actually,
But it-
Conflicts of interest.
Already.
I realize they already say that, but not in a way that is clear to people.
No, because, right, because they have two different definitions. They have definition of engineer, professional engineer, and where, you know, the arguments have gone is that, you know, engineer here means all engineers or anybody who uses the term engineer. And that's what happened, you know, so it's not written, could be very simply, I think, just written up slightly different, so it's very clear that when engineer is used throughout this chapter, you are talking about professional engineers, you know, all the way through, and that are licensed professional or something. So there's some way to fix that and not have to go through, but the other option is just to go through engineer.
Or do both. Jim?
So I think what I hear you say is to get rid of the ambiguity. It'll be as simple as adding engineer, professional in front of the word engineer and land surveyor in that chapter.
You can do that.
And that would help, and we can answer the question here by saying we are fixing this ambiguity by doing this. That's our result. And it would be a simple fix.
And basically, things would remain status quo as far as the board has always done it.
Right, and that we cannot restrict the term.
We don't have to say
We don't, except for this questionnaire that we put out that so many people responded to. And I feel there's some need to say this is what the board's decided.
I don't think that you'd get a lot of pushback from the legislature on that, just that it's a simple cleanup to fix that ambiguity. I don't think it's like, oh no, you can't do that.
Get full agencies to work, and the rest of the state agencies
Yeah,
to do it.
they would probably govern
Yeah.
agency sponsored.
Right.
So, Madam Chair, I prepared to make a motion to, sorry, McKinsey or whomever is in charge of it, if you roll up to, yeah, but it's page 21 of our, oh, right there. Option number 2 that was been previously discussed, October 25th, 2023 task force meeting. Option number 2 is to revise the definition of engineer as used in this chapter and add professional in front of the words engineer and land surveyor throughout the chapter, period.
And that would be like the next year, because this year you're already doing some cleanup, which is on at the end of that.
You're right,
sentence, right? So that's happening now.
So,
The next step.
Yeah.
I second.
We have a motion and a second by Aaron and Jim to revise the definition of engineer as used in this chapter and add professional in front of the words engineer and land surveyor throughout the chapter. Period.
And then request a friendly addition.
We don't have to.
Can I advise?
I think, let's take some questions and discussion. Discussion, yep.
Instead of it being that specific or what the AG recommends, because they may have a better result to this when we get with the AG's. And to fix this, what we're trying to fix, the ambiguity, because you may have a slightly better, and if we're stuck to this language, it may not be.
I mean, this is certainly simple.
Right.
It's a simple way to fix it.
So if the intent is to do this, unless there's some a minor tweak that has to happen, we're not stuck. with
Right,
this.
so we could say this for now, and then if we come back with actual legislative language, we could put percent
Okay.
that, and then people can be like, okay, yeah, that works. So, but stay to this for now.
Okay.
Right, and this would go to the task force to work on and put in front of the PC for review and come to the board.
Why would do all that? This is what we want to do, right? Do this. We have to go to the legislature. The legislature can change any of this. It's not a whack. They get to say, we're just proposing they do this to fix the ambiguity.
Right.
That's it. We really, I mean,
So don't work on the language.
that is the language. That is what we want to do. And let the senator and the code reviser.
Time where you came forward and said we really should be saying registered professional land surveyor. because
True,
that's what
let
our
the language
standard
come from the code reviser, right? That to remove the ambiguity.
I don't know that the code advisor will do anything
Or-
other than
Legislative aid.
type.
Right.
is. I think it's going to be a Shannon thing.
Well, it's gonna-
I just,
Yeah, the senator was gonna have to work with whoever.
But I think you want to put forward, put your best foot forward.
let's put the language forward and not just a direction to the legislature to change that.
Right, put your language forward. They can change a lot.
And I just would like to know that the committee or the task force is following through all the way through to make sure that makes sense.
You know, one thing about it is, I can't remember, I think Doug was looking at, but the definition of engineer means professional engineer throughout this chapter. Well, if you keep using the term professional engineer all the way through, then why do you have that definition? You know what I'm saying? So it might be a little bit of cleanup, just to make it all make sense.
Right. Yeah,
But the intent is to remove the ambiguity about that. Throughout this chapter, this means this, and people don't understand the difference. That's what.
okay. Any further discussion on the motion?
Is it, where that,
Is there a timeliness aspect?
I mean, for the next meeting or something.
Pretty much, we should do.
that's difficult to say because we don't, what's the next legislative session and how long is it? No.
I'd like to know what Shannon's workload is because I think this affects you more than anyone.
I'd like to work toward doing the Beagles.
What's that?
I'd like to wait until we're done with the Beagles. We're gonna be done with them by, well, if everything goes as planned, we're gonna be done with them by the end of the year.
Yeah, I think that's a very good point, that getting our fees approved so that they can go into effect next year is a pretty strong priority.
We're probably too late anyway to do anything this year.
We're not even thinking of trying to add this into our current changes. So mover and the second feel comfortable saying that this would occur after we get our changes to the renewal fees.
Absolutely, because neither of us are going to be here anyway.
He's 3 years.
I want it this year. Okay.
Do I need to revise the language to say as appropriate?
It's gonna come out.
Any further discussion on the motion?
That is, it's going back to the 1843 task force or just right to EQ? PC.
What do you two, since you're kind of both on,
If the task force isn't really making any decisions, it sounds like it's just a PC.
Okay.
all
I
right,
said, be done with the task force and give this to the PC and move on.
okay.
That gives way back.
Second. So that's after this
How about
motion,
that? John,
After this motion is complete, the chair can affect that change.
Or not.
You can always create a new one.
Okay, any further discussion on this motion?
Madam Chair,
Yes.
can we just have that motion reread? I just to be clear, I have it written down word for word as item 2, but instead I added PC to revise. Is that how we'd like that action to word
Yes.
for word with some cleanup?
Yes. Thank you.
And after,
Throughout the chapter, period.
Yeah.
Period. Thank you.
and
Yeah,
And I think
I don't think we have an understanding of the timing of it.
Okay.
I don't think we have to put that into the motion. Just helps the PC organize their agenda. All right, all those in favor of the motion, please say aye. And opposed? Motion passes. That's huge.
Yes.
As of last December, we were not sure whether we were gonna do whichever one of those choices. And it seems like time has kind of given us the guidance, so. This is a big piece.
Do you have any instructions to the task force?
The chair lives on the PC to decide whether they need a task force to assist with this as a separate item depending on the current workload.
I believe close the existing state.
I-
Survey or doodle poll.
Well, yeah, so that's my next
That's right.
piece is we have got to respond to this poll that we received. Aaron,
I first would like to see that questionnaire. I've not seen or read or had any sort of, other than verbal kind of report, this is kind of what it said.
okay,
I think it was posted on Share, but I could not find it.
We do have it on SharePoint, and instead we can send that out to.
yeah, would you,
Yeah. the
would
link
you
to it.
send a link to that? Would you first check that, so there's the questionnaire,
You gotta go.
there's the results with a spreadsheet of a bazillion written responses.
Right.
There is, the staff went through summarizing and pie charting, I think, the responses. And then in that spreadsheet, there is a column, I don't even remember what our little designators were, but whether somebody, felt that only a professional engineer should use the title engineer, or anyone who has an engineering education should be able to refer to themselves as an engineer. I mean, this is the thing, is how do you refer to yourself? It's not just about advertising or putting it on a business card. Whatever. So, there is a little key that shows how we evaluated those. And then there is, I believe, someone in that bottom of that spreadsheet, there's this many of this category. Or no, there was a percentage. It was like 30% said.
Can you show it?
And it's an unofficial
Probably.
poll, right? It's unofficial being,
We did a doodle poll.
right? The unofficial wasn't like backed by,
And it wasn't double blind and all that. It was just Chris and Elizabeth.
right, right.
Can you say again where it is on SharePoint?
Yeah.
The board. Not under committees?
And
No.
the summary of it
Board resources.
was two people going through thousands of responses. So it was just a kind of a quick way of trying to categorize.
Board research.
What-
One of those people were flying
I look for it.
36,000 feet over Indiana.
Oh, yeah, I did it. From the.
Okay, so I went pretty quick. So when
Yeah.
you get to the board SharePoint site, you want to
Yeah.
look under board resources. You'll see legislative information.
Okay.
When you get there, that first folder in blue for the 2025 proposed legislation. And then from there, you'll go down to that light blue folder for survey responses. And we'll send
That's what you
Okay, it's in the 2025 proposed.
Because that's where we started it.
I see.
originally. But we can send the links.
That's,
We will.
Yeah, Jim.
so can't the response to the questionnaire be that we had made a motion at this meeting to start the process of revising that in 1843?
And you should live it then.
I think when we are ready to put forth the language to the legislature with those changes, then we respond. Nobody in the survey is really hitting us up. And I think only one person came to the two stakeholder meetings that we had over the minor change stuff and said, what's this about title engineer changing or something to that effect? So it's not forefront in a lot of people's minds. We did respond to everybody that gave us their email address and set out a response thanking them and saying that the board is, taking this all into consideration. So
Right.
so it was a response.
I thought you asked earlier that you wanted to respond to.
I know we need to have something that defines why we're going down the path we're going down. And if it's a piece on the website or journal or?
Simple, clarify the ambiguity in the language.
And,
That
but
might be what we say.
I just want to be clear that that is, it doesn't have to be the only thing you consider or the only thing you do. That's like the one thing. And, but you've got all these ideas from, people should probably look at the results that you guys summarized before you decide. There may be other things.
Yeah.
It's not just a very simple, there's potentially others.
Any further discussion on changes to RCW 1843 concerning title? And so I don't know if we need the task force other than these things have to happen and keep moving. And so if the practice committee can take care of it in their normal business. Okay, then
So with that, I would ask the chair to dissolve the 1843 task.
I hereby dissolve the task force 1843 RCW.
Yeah. We need to credit you.
Oh, yeah, believe me, I'll
Because
find.
Dave's got to be chair.
Oh, that's why he was. Okay, all right, so. Any other last minute comments on that issue? Okay, 5.3 approval of exam policy. It's my understanding from Mike's report from the EQC that we are not taking action on that this meeting. Is that correct, Mike?
Yes, Madam Chair. My apologies for not catching that when we approved the agenda at the start of this meeting. But as reported in our committee report, there is a desire to have one last go back through and look at some of the language used herein. In particular, there was a pretty lengthy discussion about the use of words like shall versus should. And based on that, there was a desire by the committee members to have another go through.
Okay,
If I may, my notes suggested you anticipated return to board in October.
I'm sorry, Doug, was that a question for me? I couldn't quite hear you.
Was that postponed to October? Your plans?
Yeah, I believe so. That's the next board meeting, if I'm not mistaken.
Thank you. I think Mackenzie will have it on the agenda.
And I believe we're gonna, Maureen's gonna get a copy, and I'm gonna get a copy, and we'll make our edits and give it back to, Mike.
great. Okay, thank you. So we'll look forward to that from the EWC. It's
One review.
You want to review?
Well, Maureen has.
She had 5, you have 1.
She gets 5?
Now in October.
It's like cats' lives, Jim. You've used some already.
This is so important that I don't mind kind of continuing to make sure we're there. All right. The next issue, 5.4, is a discussion of the issue of decoupling, and Mike gave us a summary of the discussion in the EQC. What would you, what direction potentially would you be looking for from the board, Mike? Or what items in specific would you like discussed as part of this new business?
Well, I think that the EQC would need some direction from the board about, first and foremost, whether the board concurs that some form of decoupling should be done. There are potentially some different flavors of that, and I guess I would ask Elizabeth maybe to report to the board on the background investigation that she did of at least what some of the states that are quote unquote decoupled have done and what their flavor of decoupling is. And then based on that, again, some direction to us about how the board would like EQC to proceed in terms of decoupling. And then that would obviously entail some suggested or recommended changes to the pertinent RCW and WAC.
So do you want me to?
Yes, please.
So actually Vonna did the preliminary work on this and then I did some more, added, some more state information. But what started this was the possible use of attestations. And so what, first, there's basically two types of decoupling. One is to allow anybody who applies to go to NCES and have these attestations that they meet the requirements for education and testing and experience, and that from their state, and therefore they're able to take a test. So one type of decoupling is you don't have to come to the state first. You can go to the NCWS and take the exam. But most states that I ran across still require all of those, the same types of education, experience, and examination requirements. And those, instead of the board looking at those ahead of time, the person just checks and says, I hereby declare under penalty of perjury that I have accomplished all of those things. So they still have the requirements. So they can't go take the NCWS anytime. They have to achieve those. So lots of states have that. So you can go directly to NCWS, but they still have to meet the requirements of statutes in their state. The other type of decoupling, which I found a couple of states have done, is you can take the either exam. I mean, it's like one sentence. You can take either exam at any time. That is the truly decoupled. So as long as you, and then then their statutes go on to say, once you have just passed these examinations, you can apply, and you have to meet standards. But but the initial applications, that section on examinations says you can go to NCWS and take those examinations at any time. And then you have to come to us once you've taken and passed those examinations. Come to us then. So that's the two different kinds of decoupling. One kind, you have the attestations that say, I meet all of those requirements in the state. The other one is that you don't have to do any attestation because there's no requirements. You can take the exam.
But they still require that you have the education.
Once you come to them and apply for licensure.
At the state.
At
No,
the state.
I mean, NCWS still requires that you've taken the FE.
FE before you take the
Before you
Yeah,
take the
yeah,
PE,
yeah.
right?
You have
So
to
there's
take
still that.
There's that one kind of thing you have to jump through. And if you want a FE waiver, for whatever reason, you have to go to your state to get that waiver. So yes, they always, you're not going to get into the PE without, and they'll have the record. If you took the FE, they'll have that. So then they'll allow you to take. But yeah, that's the only thing that NCWS does say, have, unless.
And in graduation, do you have to have graduated? That's up to the state to define.
Right.
You can put it in
You
the
can put it in, it's not, you can
Right.
put anything in the
Right.
NCWS. Yeah. But what I want people to understand is the fact that you have attestations doesn't mean they're not required to meet the same exact requirements that are here. And yes, they could say, yes, I declare a penalty of perjury that I met all those and take the exam when they happen. But you'll know that they lied. And then, I don't know, do you want to license somebody who said they,
Like 5 years ago.
right, when they took the exam, I mean,
Well, the attestation,
Yes.
the attestation is that you have the education
it could be anything.
or the experience before you take the exam.
It can be, it can be.
That's not,
one or all
I don't
three.
understand that. Why?
It's decoupling in the sense that you don't have to go to the board first to get approval to take the examination. So right now, your PEs, they all come to this board, and the board, takes the application, looks at all the experience and the education and the exam, and then says, yes, you may go take the exam.
Right, because our law says you have to have the experience. So that's again, back to 1843, legislative change after the engineering title stuff is done. So that's even further down the road.
Well, this might be in joint process with the.
Yeah, so my point is you have to change your legislation significantly if you wanted the pure decoupling, meaning they could take the exam at any time. You still have to change it a little bit. We just wanted to stay out of it before they go take the exam. You want them to just pass the exam and then come to you, but they still have to attest that they really, and those requirements will be laid out. So check, I hereby declare a penalty of perjury that I have 8 years of experience. 4 of those years are NCWS red, degree. That would be a minor.
And the EQ committee, speaking on Mike's behalf, I guess, we recommended that we move forward with the, but now I'm starting to think after I've talked to Chris, we haven't even talked to the associations about this. What do they think about this whole?
Well, okay, so one thing is that we get a predominance of applications that are beginning to come in where people have taken the exam and they are not licensed somewhere else. So they are initial licensures, but they are, they've already taken the exam. And so we are evaluating their experience. So in that regard, we are already decoupled, and we've had to because this has become such a predominant kind of process.
You're decoupling in practice, but your statute says you have to have 8 years' experience before you take this exam. So the fact that you're looking the other way and allowing that to happen means that you're, what you're doing right now doesn't really match up with statutes. So
should we change the statutes is one question. And Dave?
I was sitting there thinking I wanted to make a motion not to do anything, but we don't have to make a motion to not change the status quo. Is there a motion to make a change to something that someone would like to make?
There was a recommendation by the.
Yeah, and Dave, I guess one thing that the committee discussed is that if we do nothing right now, we're essentially turning a blind eye. We're either going to continue turning a blind eye to all of those applications, as Marjorie mentioned, where people are doing this, they're taking the examination well prior to their 8 years of experience or 4+4 or however we term it, or we're going to have to start enforcing our statutes, which means rejecting those applications because they do not meet our statute, right? We would have to tell them, sorry, you've got to go retake the examination now that you've got your 8 years of experience, and then we'll consider it. Say again.
Go through it.
it's a statute.
Well, Dave, it would be awful if we said to everybody coming in, oh, go get licensed in another state first, because we're not going to accept you because you took your exam before your experience. I mean, it is a significant number of people.
This has been going on. I got my PE license in California.
Well, did you get licensed before you came here?
And I had a master's degree, so I'm looking for 2 years of experience to get a PE in California, in 1980, whatever. And I got my PE license in Washington. This has been going on.
But you were licensed in California first?
Yes.
Okay, so that's a comedy.
That was a con, yeah.
Different.
But we still looked at your.
This is the, it's the first.
Took the exam
Yes.
for 4 years. This
I know, I agree, I know exactly what you're doing.
You can cancel my license?
Yeah.
Let me just say there are many problems with that particular statute.
Yeah.
There's ambiguities, there's, like you said, it says specifically you have to have 8 years of experience before you take your PE exam, and that's just not the reality of a lot of people who come in. So it's just another thing that the statute is.
Is this cleanup then?
I mean, maybe.
Maureen, your hand up?
Oh, no, I'm sorry.
Okay, I'm sorry.
I did, and I would say, I don't believe your mandatory 8-year before exam is in the language. The language for registration says, this is the minimum evidence to be licensed. Be your satisfactory to the board's qualified for registration,
So the way.
not to take your exam.
Sorry. The way that the statute is written is very odd. So the first section basically says, this is what you have to be an engineer. Then it goes down into where the FE requirement is, if you keep reading. It's like as an EIT, but then it goes into the actual process and your examination requirements. It goes into a bunch more detail down there. So I think of the first one as kind of generally, here's what you need, generally. And then below, it's like, okay, specifically, you need to take 2 exams. You need to take an exam on FE, fundamentals, and then you need to take a science exam. And then before you take the practice, once you have the 8 years of experience, and I think I have a document we can put up, but once you have the 8 years of experience, you take your exam. So it's lower down in the statute, but it's there. And like I said, one of the weird things about it would be so much nicer if that just said, here's how to get licensed, or here are your requirements for licensure. One, experience, 2, education, 3, examination.
Yeah.
But it doesn't.
And Dave, yeah, I'm sorry. You guys can't see my body language, so I'm sorry if I'm interrupting anyone.
No,
Dave, back to a comment that you made about how you got your initial license and then applied for Washington licensure via comedy. I mentioned in the EQC meeting, I have a very similar pathway, and recently I applied for licensure by comedy in another state, Kentucky, and they dinged me on my comedy application because I did not have, by their judgment, 4 years of experience after education prior to taking the PE. Now they are decoupled in the sense that they offer an alternative pathway that they call evaluation based on education and experience only. And they essentially offered me two options if I wanted to be licensed there: either go take the PE again now, or have us evaluate your record for licensure based on solely your education and experience. And clearly I chose the second. So I guess I mentioned that only to say that, yeah, some jurisdictions are dinging people for that.
I also want to add the wrinkle that we do not have to treat survey the same as PE, nor do we have to have the same attestations for SE. And there are states that have decoupled PE, but not survey. So there is an option to do things differently there if we felt that because of that whole issue of you don't actually have to have education. Might be something where we don't decouple the survey.
It's the experience. Education gets your foot in the door and out in the field, we do that certainly.
Right, but we don't have to allow for decoupling if we want them to have the experience before they take the NCAAS exam, so. All right, so do we have a motion?
I'm thinking of one. So help me with those 3 minutes, but what I'd like to convey is, I don't necessarily agree with decoupling, but I want us to not put up barriers to those that come from the state that's decoupled. So I'd like the EQ to look at language changes that allow for that. Yes,
You're making a motion. 1840 death.
It sounds to me like it's a language change issue to allow people from other states to get licensed here, even though I don't agree. I don't want us to say, oh, yeah, we will let you take your exam early. So I don't know how to.
But they aren't people from other states, Dave. They're people from your company. They're people from,
Yeah.
That's been going on. People go to California to take their PE.
So
they don't
For
have to
decades.
go to California. They just have to say I'm getting.
Well, they used to have to.
Yeah.
Well, right. This is the language that's problematic for all. It's 1843, 040, 040 subsection blah, subsection A. At any time after the completion, so at any time after the completion of the required 8 years of engineering experience as defined in this section, the applicant may take the second stage of the examination upon submission of the application and payment, to the board here. So it's that little sentence is the thing that's hanging, if you've been ignoring it, it's the hang up for, for this situation. It's not just decoupling. It's a problem for, as you say, it's a problem for a lot of applicants. So it may need a bit of change.
So could I change my motion to just simply state for EQ to review the language and RCW?
To Dave, just clarification, to what end? I mean, you at first you wanted to not create barriers for comedy applicants from other states, but do you also want to remove potential barriers for in-state applicants who are applying for their first license as a Washington State PE or PLS and have taken the examination well prior to this required 8 years of engineering experience? Or I guess what are you asking of us?
That's the question.
Well, I don't think it's a barrier. If you live in Washington State, follow our rules and procedure, we'll give you a license. I guess it's more of a barrier if somebody from another state.
And I add, in the committee meeting, we talked about the barrier being the fact that there are people in Washington State who know that they can go to, can take the test in California or take it virtually, whenever they, pass the FE. There are those other people in Washington State who may not be as connected and not as in the know, and they're waiting because our statute says you have to wait. They're waiting and taking the test after they have the 8 years of experience. And so that could put them at a disadvantage because they're not taking the test as closely as they did to getting out of school and taking the FE and, when everything is fresh in their mind sort of thing. And that was the barrier we were talking about in the committee. We want to make sure not only just to clean up the language from the standpoint of what's happening versus what the statute says, but also to make sure that we're letting our constituents know this is an option for you. That was being exactly decoupled, is to let people know in our state that this is an option for you.
So it could be as simple as at any time during the completion of the required 8 years.
Because that would still retain the overall experiential requirement for licensing.
Yeah. But it basically allows.
Decoupling meaning not decoupling the agency or the board from the process of taking the examination, which is kind of part of what people think of as decoupling, but it's decoupling just that policy or that requirement. Having 8 years of experience, like that won't be a requirement for taking for anybody.
Try and get everybody to motion.
No, not entirely. I think it needs to be worked. But I would call attention to the fact that there are some business values and separate it. NCES gets all the test money, but we don't necessarily have to. So that discrimination, you know, like Oregon currently benefits, they don't even see anyone until all their tests are done and they have their experience. Then they come to the board. And that's the same kind of thing you're talking about here. But just the benefit that's been called by the committee here is we want people to recognize that implicit decoupling we have could be available here in the state. And we're not advertising it. Well, they're not getting the form, they're not getting the journal because they're not licensees yet. So we'd have to post it some other way.
And basically then you're posting that it's okay to violate. That you're gonna accept it unless you make it.
Unless we change
have to look at our law. We can't
Yeah,
continue to violate our law, even though we say, hey, it's just sign of the times. Jim?
Interestingly enough, you look at the paragraph below it, there is no restriction on experience for taking a land surveyor's.
Correct.
So we can
Jim,
change.
it's further down. It's at the very bottom of the screen under D part 2.
Time and completion required. Okay, yeah.
So. it's
Either way.
Well, Dave, do you want to either restate your motion or?
What was the motion?
Hasn't been fully.
Can you repeat?
But you said, I want to do something like, I want to make the motion that has something.
I just have EQ to review language, varsity that we to review for
To be.
It sounds to me,
so what you got.
Jim?
it sounds to me like we have to change 1843.
Yeah, I think that there is the issue that we are currently accepting applications where it's clear the applicant had taken their test before they finished their experience.
Yeah.
And
So should the motion be that we need to change 1843 to reflect our practices?
I think it's either that or we need to start rejecting applications.
Which is really a good option.
Nope.
Rejection applications.
Very.
That's a best.
Talked about, like,
Here, exactly, you were here.
so it's been since 2000,
It's been going on since I started with the board.
and it was something to do with the way it was explained to us, and it's in the EQ note somewhere. That it's an applicant for exam, sooner than an applicant for initial licensure. This is, they're not, when people come here after already taken the exam, we were told we could give, you told us we could. I remember you, because we wrote it down in the EQ minutes.
Okay.
It's in the board minutes or EQ minutes, and it's been talked about within the last probably 5-10 years.
Okay, well.
And so we
I
did,
don't
yeah.
remember saying.
Yeah, it was, because it was like, no, this is an applicant for exam. An applicant may take the exam. They've already taken it, they're not an applicant for exam. Is how it was kind of explained, how it was interpreted for us back then.
An application for registration.
Yeah,
What's it under? I mean, it's such a weird
because it's
statute.
written so weirdly, yeah.
It's such a weird statute.
I would like Jim,
I like,
Yeah.
I like what Jim said,
Yeah.
something like, have EQ review 1843 for consistency with current trends in development.
Yeah.
is that Dave's or Jim's?
That's my.
Okay.
Dave made a motion
Okay.
that the EQC move forward with looking at the language of RCW 1843 as it applies to current trends in processing licenses.
Applications.
Application.
Okay, for 1843, so looking at language for 1843,
As it applies to our current trends in processing applications that are decoupled. And do I have a second?
Can you make 1843-040? Can that be a?
040, you want to restrict it?
No, there's more in here.
There's more than before.
Yeah,
And
posted, so I was a little bit about examinations, but I haven't looked at it. See. Okay.
So that was EQC to move forward with looking at language for 1843 as it applies to our current trends in processing applications. Now, Dave had an original motion that was made that's slightly different, that did not get a second.
it didn't get seconded, so I think it just evaporates.
So are you withdrawing your original?
Yeah, whatever that was, I haven't gone after.
So I second.
Thanks.
All right, I've got a motion and a second by Dave and Jim. Is there further discussion?
The only other thing I would add is I still don't believe it's the best approach to licensing. You know, but I think we need to be aware and not have barriers to those that choose this path, the licensure.
We also need to consider all disciplines.
Yes, which?
Jim?
What about, what is the experience requirements for on-site? Do they have to have experience before taking the exams?
Yeah, and they're under our control, so we can keep it that way.
And so do we need?
Is that
Okay.
18?
We don't want to decouple that? We don't want to be fair to the, we don't, okay.
They're not NCAA, it's just a state exam.
As a matter of fact, we have gone the opposite direction. You.
All right. I'm going to take a vote. All those in favor of the motion, please say aye.
Aye.
Opposed? Motion passes. Oh, yes.
For those of you who don't know me, I'm Ed Houston. I'm here for something else. But I've worked for many, many years in examinations and with NCWS. And I was chair of the instructional exam, the EP examinations for Professional Engineers Committee at NCWS. While I was there, there was an interesting charge one year that said, how are our exams differentiating between practice and education? Because there's supposed to be principles and practice exams. Principles is the education. Practice is what you do in those 4 years or 2 years or however many years after you finish your education. And the outcome of that was there's some interesting language at the beginning of questions that indicates really whether this is a practice question or a principles question. I'm just a registrant here in Washington, but it would be interesting for me if the Washington board wanted to ask NCWS about, based on the decoupling, about things like pass rates. Are our exams merely principles exams now? You can pass them after 4 years without any practice. Or are they principles and practice exams? I think that would be a fascinating thing to hear from NCWS about.
I have asked and I will ask again. Tell me how many people have taken this exam who don't have experience.
Maybe if the Washington board sent a formal letter and asked.
Okay, that's an idea. Right, I am thinking that we maybe take a 5-minute break before we have this much fun on the topic. It's 5 minutes enough for everybody to just kind of stretch. Okay, thank you.
All right, Mike, I don't know if you're sad, that's 1:58 that we passed. Or 50, I think it was 58. So,
5 minutes, Mackenzie, is that what I heard?
yeah, 5 minutes, thank you, Dave.
And 4.
Well, I think I need to get it.
Back. Mike, are you there? Okay, we're online and we're recording. And Mike, are you with us?
Yes, I'm here.
There you are. Thank you. All right, moving on to new business item 5.5, the US-UK Mutual Recognition Agreement. I reported out earlier on some of the issues of the task force. And as part of the new business, we just want to talk about how we see moving forward or not with whether we support the MRA fully or whether we have various different limitations or requirements further for applicants. And so I think it has, one of the things that we're going to need a motion on as part of this new business, that we are definitely going to have some amount of additional requirements. One of them being that the structural engineering licensure does not use this process, that they still have to go through our standard application process. So that's clear. Surveying is not an issue, neither is on-site as part of this. And so the issue then is PE applications. And I've invited Ed Houston, as I mentioned earlier, to come and share with us in this discussion and to give us any insight in terms of the international engineering consulting engineers council, no, the engineering consultancy.
Okay. My background on this, just FYI, is that I am a member of the Institution of Structural Engineers, SRD. This board actually, back in about 2003, said that they were concerned that BC was allowing the example of Washington, then this exam, to be used, but they also now we're going to allow the ISTRAT-E chartered membership exam to be used. And the board asked me to come to a meeting, and they said, no, we're concerned that someone in BC to ask us for equivalence with the ISTRAT-E exam, and someone needs to know more about that exam. Someone has to take it, Ed. So I did. And shortly thereafter, I was asked to join their exams panel. So I was never an examiner on that panel. So I have good insight into the ISTRAT-E, and I know that that's not what you're talking about equivalency with, so I'm not going to go down that rabbit hole. But I also have some familiarity with the CEng, the Institution of Civil Engineering, their license, their chartered member, because the way the Engineering Council in the UK works is once you are a chartered member of one of these learned bodies of engineering, you can then pay 100 and something pounds a year and become a charter of a CEng, or I don't know if they use a Struct-Eng or an M-Eng, but you become an engineer with authority to be a responsible charter of a project. I don't think it's quite the same thing as we do here with stamping drawings. Yeah. So the CEng process, and as I understand it, all of the other engineering processes with various disciplines, okay, are that when you start your first job, you start a portfolio of that documents your experiences, documents your progress, documents the decisions you make. And you are assigned a mentor who works with you on that whole way. And at some point, after 4 or more years, you can then go before the board of boards of each of these learned institutes and put yourself forward, become a chartered engineer. In the struck in, there's also a step before that, rather like our fundamentals. Although it is an examination step there, as struck in, which is also an examination step for becoming a chartered member, not the way it is in other organizations. So the route after you have your portfolio, and we're going to do this, is you're going to write a couple of essays that are assigned to you, and then you're going to go before a board, they will have had your portfolio, they will review it, they will ask you some questions on it, and I understand that they will put forth to the applicant a challenge question. You know, if you were presented with this on that project that you did, what would you do? Which is, I think, how they throw ethics into it. And at the end of that process, you are or not a chartered engineer. It is not based on, it's based on what you did on the job, not necessarily coupled to the Euro codes, for example. So none of these processes are code driven. The I-STRUCTI process, in fact, does not only test for seismic, but wants their chief examiners to minimize the amount of wind content on project exam. So, you know, here in Washington, we have our seismic problems, but we also have a pretty large wind hazard. It's been a number of years since we've had, you know, the Columbus Day storm, the Hanukkah Day storm, or, you know, half a dozen day storms that have done a lot of damage. So in the CN, and as I understand the other learning societies, chartered engineering, the whole process is not code-based. So if you, in fact, then come to someplace in another country, it would be incumbent upon you to learn those codes, but there's no regulatory basis where you would have to show knowledge.
So what they say is and YMCWS has accepted this, is that they've broken it out into all of the competencies that are tested by SWS. So basically all of those competencies are mapped to various projects, and then, you know, questions on projects. So it's kind of, there is kind of a low examination based on projects. And then it takes about 10 years to cover all of it. So that's kind of how NCWS made that comparison. We still test all of the policies that they do it. And it's very experienced as opposed to NCWS, which now doesn't sound like so exciting.
I think the as experience based for NCWS really depends on the exam. Going back to that EPE experience, each of the exam chairs for an EP that year were asked about their exam and whether it was principles focused, practice focused, or a blend. And for example, the chemical engineer chair said, ours is completely principles based. And a couple of us took her aside afterwards and said, really, why? They said, we get more results if we ask a practice question. I'm not sure that's what he said, in not ask practice question, but that was what I was told. I would say, for example, the structural exam is very much more practice-based. So,
If someone was to come and ask for a PE licensure here, and to do structural work at a PE level, what would their experience have been in the UK? Because for one thing, we kind of put on our roster sort of what discipline someone has tested in. I don't know what we will do if we're just kind of using more of a straight product. Where would they come from if not I-Struct-E? Can they design buildings without having an I-Struct-E in the UK? Or is that the only avenue for any kind of structural design?
I don't actually know if you go with a C-Eng and you build it. I don't know that. It might be similar to what happens here in the US between, for example, architectural engineering, civil engineering, and structural engineering, whereby with a C-Eng, you might have enough structural experience from college, university to, do a subset of structures. That's an interesting question. I can try to find that out if you'd like.
Yeah, I mean, I think that is one example, because that's where my mindset is, but the same would be true, say, of geotechnical. Do they have all these different disciplines, then how would they translate to what authority or not authority, endorsement would be given?
That what you're saying about the UK thing being based more on practice. That's almost a good thing, because the way we're headed here, when somebody can take their PE exam 2 days after they get their EIT, I want to rely more on practice than we used to.
Right. I think the question is, perhaps, if someone is coming to Washington State with a rich credential, UK credential, do they need to demonstrate some familiarity with US codes? Washington State code. Because even after you have practice and you have years of practice, you still ultimately have to design a code conforming project. Regardless of your branch of engineering, there are codes, or for example, in naval architecture, there's this whole federal requirement, set of requirements for designing ships. It's not as code the way we think of it as a code, but similar.
Karen.
That's where I'm going with this. It doesn't preclude the registrant or the applicant to not be versed in code, both local and or regional or federal, whatever code exists at the time. From my limited understanding of engineering, there could be a code which is like 2024 code, which has been accepted in one locality, but an older code is accepted in another locality. It doesn't mean that, I know the IBC, and I have to know the year in which it's applied within that locality. I may be simplifying things, forgive me, but I don't think that what we're talking about precludes the the applicant or the registrant to not know that code. I think what we're getting at is whether or not they are competent to, minimally competent to practice engineering. They still have to be competent to practice within their expertise. Okay, so whatever codes change, that doesn't preclude that applicant to not study that. So whether this UK MRA is right for us right now, as code changes, it doesn't mean that we're always going to come back to the time in space where that MRA was signed, that, oh yeah, you got to know it at that specification.
Yeah. The other issue I'd like Ed to comment on is we have a concern that we make this agreement, we move forward with some kind of agreement with UK, and then we have applicants from other countries come in, and especially our desire to be a good neighbor with Canada. How would this affect the way other engineers who might have the same level of experience if we say, you have to take a PE exam, but the UK engineer does not? Any thoughts about other jurisdictions?
Yeah, from, I have to be careful because I wouldn't say a set of blinders, but I have a color of sunglasses, I guess. But from my iStruct-E, the lens I see things through is the iStruct-E experience, where that exam is now given in 105 countries, I think. And it is completely decoupled from codes. You can sit that exam in any code, and they'll find someone to grade it. And so a lot of the engineers, for example, at GC, who have constructed, majority of them will have taken the iStruct exam with BC codes. What happens with the other disciplines, the civil would probably be my closest, is although they say they map, NCWS has said they map the outcomes, that registrant still hasn't been tested on their competence codes.
Especially local codes. And the same is true with, we think about this in a holistic way. The MRA still allows and requires NCES applicants to the UK to there's an assessment to make sure that they understand the local knowledge and competence that works in that specific jurisdiction. They have, so it looks like they have several assessments that happen once you get there.
In the UK.
In the UK, from people coming here to go to the UK.
Right, but we don't have that assessment here. Other
Not yet, but the state could have an assessment.
It is in the MRA both ways that
if we wanted to.
you may be subject to.
And this actually says will be subject, coming from here to, I think our side of the MRA says may be subject to, but this basically says, I think, they will be subject to assessment.
And one of those assessments could be, this is the PE exam, in your discipline.
Right, yeah.
Here, yeah.
So we're falling back to that.
One of the things I heard about from the couple of people who I interviewed before coming here, Marjorie had indicated what she wanted me to talk about, and I wanted to make sure that my knowledge, particularly of the Institute of Civil Engineering and their process, was that I understood well enough to be able to speak on it. One of the things that someone mentioned to me was they had come into the U.S. from UK after 15 years of experience in the UK and had to then become registered in the U.S. and had to pass both the fundamentals exam and then the PE exam. And said that the bigger barrier was passing the fundamentals exam.
Yeah.
So everybody said, yeah, I've heard that a lot of times.
Because they're so far away from those initial courses on thermodynamics and everything else.
We have made a law change, which Shannon, help me out, is it in law or it's part of our new?
It's in law.
It's in law.
Yeah.
To waive the FE for foreign applicants that have.
Accept an equivalent exam.
That have an equivalent exam, that have.
No, there's two, there's
Waiver.
equivalent
Person,
Or a waiver, right?
the equivalence of
okay.
law.
Okay.
equivalents
Or
and
experience, certain level of experience, so we've had heartache over that ones.
So it would be a lot fairer to a candidate coming from the UK or from Canada or from Australia, or New Zealand, practically any of the crown colonies, the old crown colonies, because I think they all use the same process. For them to sit the PE exam does two things. It shows they have code knowledge. It also shows that they understand the system of units. Because that, grading exams for people in other countries, the first thing I had to do was develop an Excel program where I could quickly translate, the units. And, that we might think of that as not necessarily a big problem, but I think the very first Mars lander crashed into Mars because someone had not converted meters per second to
Feet per second.
feet per second correctly.
It's new accessibility.
Yeah. So, so I think the answer to go a little more specifically to your question, Marjorie, is that it's one thing if we're talking about people from the UK. How that translates to people from Canada is probably where we're getting most of them, although we will get some from other crown colonies, versus someone who's coming from South America from a different system. And creating a level playing field for all of those is, I will be interested to see how the board does this short of having people take the PE exam. Because the only other way I can see of doing it is to create a supplemental exam that deals with all of that across all of our disciplines. And
And we can accept, right now, we don't have to do anything. We can accept UK engineers right up to the point of the PE. And they come and pass the PE, just like we do with Canada and other countries have to take the PE exam. And then once they take that, they can apply for a common license with us.
And it doesn't have to be pursuant to the MRA, it's just.
Yeah, it's just where law allows us right now to do it.
Right.
But if you participate in the MRA, I guess you could say that all you're requiring on top of being an NCES approved MRA applicant, is all you have to do after that is take the PE if that's.
Well, the only problem is that the NCWS and the whole MRA process actually is more rigorous than a UK person coming to us now and just taking the PE exam. Because they require 7 years, 2 years of responsible charge of a significant engineering projects. And so we don't require that now. And so if we accepted the MRA, but maybe the PE exam, we're actually having more of a barrier.
Interesting. Any other questions for Ed or discussion items in general?
I'm ready with the motion.
Oh, motion? Okay.
Well, I think it'd be good to get some direction. And I move that we sign the MRA. And develop a policy statement on how we're going to apply the MRA to Washington State.
And so by signing the MRA, it's my understanding that you're saying not, that they can not take the PE, that they can be approved without taking the PE exam. Because
I thought you just said we could add in whatever we want.
we can add in whatever we want, but according to our embassy connection, he said it's a deal breaker.
Yeah.
But I'm also,
The PE exam to be.
I'm probably saying I'm okay with that because I really don't like that somebody can take the PE 2 days after they get their EIT.
That's a domestic.
And that's already gonna happen too. So a UK engineer who's got all this experience in this critiquing, why they want to come here and learn our codes to do a job, that's their business. But I have more confidence in their engineering ability, from what I understand, than where we're headed with our testing. I mean, I think we've diluted the examination process. I mean, it's not, how can it be a practice exam if you can take it so early in your career?
Well, hopefully they don't pass it.
And like you
Hopefully
said,
the
they're
writers are writing.
going to eliminate those problems. They're going to eliminate those problems. They're too hard. Too many people fail that. We got to get rid of that. I mean,
That's why I sat on
Anyway, we're in
that
discussion.
with the structure. Say, can I be confident that the item writers are writing a exam for the level of competency for 4 years experience after graduation? And that there isn't any going back and pressuring or lowering the pass rate to get the percentage up to where it has been. They're not doing that. So I'm more comfortable. Karen?
I would second his motion that we sign the MRA and
Develop a policy.
So it's not signing the
Don't
MRA.
sign it.
It's agreeing to it and developing their standard. We don't sign it. We're not signing.
So can you explain what they're asking
We're,
to happen next?
they're asking us to,
Next Tuesday.
they're asking, well, Tuesday, it's just ceremony. The
But
signatures
they're
happen.
fine.
You're going
Who's
to,
signing what?
The NCWS people are signing and the UK component.
Okay.
we're not signing anything. We
They're signing
agree
MRA.
to the process and we build it in NCWS record that Washington State, you're UK, this is the process you have to take. If we put PE exam in there, we're out. That's what we were told. If we require a PE exam, we don't need to do anything.
Okay, my motion didn't include
Well, no, I'm just saying,
requiring it.
yeah, okay.
So is it incorrect motion to say we're signing?
Signing, just say we're agreeing to and will participate in
In the MRA.
conditions of the MRA.
Okay, so please make that correction.
Okay, so we have a motion on the table from Dave, seconded by Aaron, to proceed with agreeing to the MRA and working on our state requirements.
Yes,
Is that correct?
in the form of a policy.
And I think
It's the ES Bible.
I didn't get a chance to, and I don't need to talk through the table, but the one thing that I do know, and Shannon would agree with me, is there will need to be a law change. Just because of the way, how specific the testing is.
Right. Okay, so not a RCW change, but a WAC change?
Right.
Okay, Jim?
Well, wouldn't it be also the RCW change because it requires the examination?
But approved by the board.
Right, and there's
Yeah,
discretion
there are,
It
they
can be
have
oral
an
and written.
examination of sorts, so.
Okay, but, so your motion was to agree with them already. And create a policy, and that policy may or may not include requiring the PE, and if it requires the PE exam, it's a deal breaker, right?
It's, we're not agreeing to the MRA. So that would be a circular motion.
Right.
So
It's basically.
that means, this motion means that there will not be a PE exam.
Yes.
Clarify that, David? You made the motion.
Not be a PE exam.
Yeah, I'm okay with that.
Okay.
Second.
Okay, Maureen, you,
Jim asked my question.
okay. Mike, any questions before we vote?
No,
on-
Jim essentially asked my question as to whether Dave's motion, within that, it was implicit that there was not going to be a PE exam, and I think it's been asked and answered.
Okay, any further discussion? All those in favor of the motion to agree to the MRA and develop a policy and change the WAC in order to proceed with agreeing to the MRA? Please say aye. Opposed?
I'm sorry, can I get those hands again? That was Maureen, Jim.
Agreed.
Marie, Mike?
Agree to it.
Like, I oppose.
No, you oppose.
Yeah, Mike, I need your vote.
Yeah, I'm sorry, nay.
And I have the deciding vote, it's nay. That's the only time I get to vote. Did you?
Wow.
You naysay.
Nay.
Okay, so
I don't think that this issue is gone. I think that we can continue to evaluate how we want to proceed with these issues, not only the MRA. So I guess my subsidiary to that is we don't need to go around saying to everybody, we disapproved it. I think the issue is that we did not approve it at this meeting.
Right.
I think you guys can still go to the signing and encourage mutual agreements, but we're not ready to proceed with what it will take for this one. Is that fair?
I would seek further direction because the request and the invitation is specific. And if we are not in agreement.
Yeah, takes the wind out of our sails.
It, beg to correct, the invitation says those boards that are willing to pursue participating in the agreement, not yet there. You don't have to be there, but, and that's what Marjorie was clarifying, that we would still be interested in pursuing participation. It isn't that we're agreeing to participate.
Can there be a different motion?
can I read the exact language?
Yeah.
We are planning a ceremonial signing for interested member boards at the British Consulate in Chicago. All member boards need to do is take part in, to take part is express an interest in pursuing participation in the MRA. It's not required that the member board be ready to participate at that time. Some boards may need law or rule changes and other meeting and process changes that will take time to complete. There is no time requirement imposed on member boards. So it's just expressing interest.
Well, we just had a motion that pretty much said.
You're not interested.
Okay,
Not interested.
we can go with that if you want. I mean, I was not really wanting to entertain a motion until we talked to the other Western states about what we could do. I mean, it has been my desire to kind of have a Western states coalition on how we see this and how we see partnering with other countries. And so that's why I guess I was trying to put a little padding on how we proceed from here.
I don't know if there's a reason we have to go and say yea or nay this meeting.
I think the wording of the motion is specific enough that we did not agree with the MRA. And therefore, we didn't say that we still show interest, but we are not agreeing. We didn't say that we're interested, but we're not ready to go forward yet. We specifically, the motion specifically on the floor was, and I seconded, that we are not in agreement with the MRA.
This is your timeshare meeting.
And so I, personally, in my professional and personal opinion, I think there may be some others within the government system who, the governor,
Namely the governor.
maybe the governor, that is a proponent of similar breaking down barriers, at which may put this board at in the light that you don't particularly really understand.
Right, I'm not sure I would agree with that. I was there, I know what the MOU is. Governor signed an MOU for a trade agreement. It didn't say specifically what to do about a trade agreement. We are agreeing to moving forward with helping the UK bring advancement of trade, engineership. We already are there. We will allow them to come in. They still have to take the PE exam. That's not a huge barrier for most engineers. I can tell you that. So taking that PE exam needs a rigor and a study. Is that a barrier that's unfair and the governor wanted to remove that? He didn't state that in the MOU. He said agreeing to a partnership of trade exchange. And he signed it specifically talking about architects and engineers as well as all the aerospace industry.
Did the architects?
They
have an exam.
No, they thumbed up it.
No, but they have
They take
a
the
world.
same exam.
Oh, they all,
All-
UK takes the same exam as the, I did not.
They use the NCARB exam. So it's pretty
Doesn't matter to them.
clean.
Already.
Yeah.
So under what circumstance, so we're gonna go to this ceremony in consulate, somebody's house. And right now, we're thinking, well, this board's never gonna accept it. Why are we wasting our time with this thing?
It could be, the date and time, the logistics of this, with the date and time to sign up for this was back in June.
Yeah,
I signed this up, but I expressly told NCWS, we're not there yet. And so whether we get there, I didn't say we're gonna get there, I just said we're not there yet. And they said, please, we're not asking you to be. Just if you're interested in pursuing this engagement, then go for it. If you think this is not pursuing it, then we can regret.
what is the next step? We just voted not to accept it. So what's the next step?
We should not have. That'll go.
Well, what Oregon's doing is they're sitting back. They're not gonna participate in anything, but just sit back and watch. And because they don't know what they want to do. They right now agree to where we're sitting right now. I know that they're not sure how the code, but they have received 4 UK applicants over the last X amount of years, so it's not a big deal to them. So, I mean, if you want, I'll send a letter and say we won't be there.
Well, or go. I mean, I don't think that it's deceitful to show up since have scheduled your flight times and everything else. Go and gain information, which is why we're asking to talk about it at the Western States Forum also, is to gain information.
And I think you can say, as of this meeting, there's, the agreement is after this meeting that you're not gonna go forward with it. That doesn't mean that 4 meetings from now, somebody can bring it up again and say, now we know more. So I'm gonna, we want to discuss it, or maybe raise another motion, see if then with the new information. So this doesn't preclude you from ever doing it. Right now, you're not gonna do it in the near future.
You may also find, sorry.
Yeah.
You may also find that other states also have concern and want to impose a PE exam. And so this deal breaker may become not a deal breaker at some point, if enough states say this is what we need.
Okay, yeah, that's interesting.
Yeah, maybe convincing them that they have to take the PE. They want the agreement.
Right.
I need to move us forward. Doug has reminded me that we have plenty of other items on our agenda and we're running low on time. Thank you, Ed.
Glad to do it.
Yeah.
Oh, by the way, one of the thought might leave you with. For each of the disciplines who have an organization in the UK, perhaps go to the current board of the mechanicals or IEEE, and ask them to designate someone to inquire
Yeah, good point.
with their UK equivalent about what the process, what that particular discipline's process towards charter membership is. You might get a lot more information, because I can unfortunately, only talk about the bit I know about the civils and what I heard about structure.
That's a very good point. Very good.
The other thing I will leave you with is that, I know structuralism where you're talking about, but ISTRD has started a process to let US registered structural engineers become ISTRD chartered members by taking a small oral exam, about a 3-hour process. They go in, they look at a building, and then they come up with a couple of ways of how that client's brief might be constructed or might be designed, and then they go to present that.
Yeah.
And I've worked with ISRD on generating those problems and interviewing people. So even ISRD is saying, if you want a K credential, there's an examination step.
Which is what this says as well. There is an education, I mean, they still have steps that you have to take, right? You still have to take the debate.
Board or whatever.
Whatever their thing is where you show all of your work and you're questioned about all of your work.
Yeah.
That thing, you don't have to do that.
Yeah.
Okay, take one more time. Thank you.
Good to see you. Thanks
so
for that.
much.
Thanks, Ed.
Thank you.
Wish we had a bag of swag for you, like, far away from God.
If you need any other help, as you go forward.
Thank you.
Bet.
Nice to see you. Good to see you. Really appreciate that.
Okay, on to 5.6.
Sorry, parking back.
Yes, thank you.
I'll get it.
Don't knock the table over on the way out.
Yeah, sorry. No worries.
CES annual meeting motions and directions. We talked about some at the last meeting. Are there any issues that we need to cover before heading to the meeting? And do we need to have a motion to allow those at the meeting to vote on?
I think that Marjorie be our designated voter. But they have- Well, we have to have a button pusher.
Yeah.
So you're the button pusher, it's my motion.
To eliminate the possible meetings.
Yeah, one vote
Oh, that's right.
I'll second with the advice of the gallery.
Any discussion? We have a motion for Marjorie to be a button pusher and previously seconded by Jim or by Doug. Further discussion?
Does Marjorie have a backup in case, because you want to travel? Who is our designated backup?
The vice chair. Yeah, okay.
Is that a friendly amendment?
I just asked the question.
She can delegate. Territory.
Yeah. delegate when the time comes. All those in favor? Say aye. Opposed? Motion passes. Is there any discussion of the motions and directions during this meeting?
As far as discussion, most of them are milk-toast. I really wasn't much objectionable, but it's not already on, it's not off the consent agenda.
Okay. All right, good. Now we're getting to the most important issue on my agenda. Potential fee increases. As mentioned in the, and do we have Ian coming on at this point?
Ian is online.
Ian, thank you for joining us. Appreciate it. Ian is our financial advisor. He's with the Department of Enterprise Services. And
Good afternoon. Can you hear me okay?
yes, thank you. So I briefly talked about your budgeting and your different scenarios, which are all in the package. If anyone has a question about that, we can certainly discuss them. We want to look at approximately a 10% increase in the fees for renewal applications. And so the motion I would be looking for.
I'd like to move fee adjustments for one.
You have the actual numbers. We have.
Yeah, for $120 for land surveyor, engineer, and on-site renewal with late fees of $64, being 50%. That's general calculation.
And firm renewal increase of.
To $121.
All right, we have a motion by Doug, seconded by Maureen to move forward with requirements to change our WACs to increase our renewal fees for PEs and PLS and on-sites to 128 with late fees of 64 and firm renewals to 121. Is there any discussion?
Yes, clarification. This is the second option in the packet where it's just the renewal fee revision.
Yes. Well, the both.
I guess I would like to talk about which language we go forward with in a minute. I first want to just approve the fee amounts, and then let's talk about the WAC length, the two options, because
Okay.
how we present that and move that forward is important, but yeah, Aaron?
So, sharing sort of what the original cause of this, it sounds like it's much more of a inflation due to inflation. Is that correct? Because when Paul was here before us and before Paul, we always were nervous about funding sweeps, and that we're underspending, and we weren't doing enough outreach, and we wanted to make sure that we hit our stakeholders with good quality discussions and doing that. And now it seems like, well, now we just don't have the money. So I don't understand.
I would like Ian to address that. I mean, that's a great question.
Yes, certainly valid concern, and the materials in the packet do attempt to address both of the risks, both the risks of leaving fees at their current rates as our expenses increase, and the risk of over collecting and our fund balance growing too high. That's why there's a number of scenarios in there. There's really two drivers that I see for that caused us to need to look at this. One is, like you said, just general inflation, costs of goods and services rising over time. The other is the addition of some new positions within the agency and adjusting some of the current positions' compensation. So those are really kind of tipping us to where our expenses are now projecting over the long term to be right there with our revenues, if not slightly over our revenues. So over the long term, adding these positions is showing expenses higher than those revenues, and that fund balance decreasing over the long term. The rate of 10%, I feel is, and the numbers have shown in some of those charts on a few pages down, that a 10% increase kind of limits the risk of over collecting and seeing that fund balance increase, because we don't want to see the fund balance increase too high. We want to keep our expenses and our revenues pretty level. Does that help to answer the question? Anything else I can clarify?
Yeah. I was also going to say, obviously the exec team looked at this, or exec committee did this. Was there an adjustment to the benefits side of the equation, saying, was there a cost benefit analysis? Yes, we're going up 10%, but our registrant's going to see a equivalent change in outreach and benefit of the process of efficiency, and are we prepared to go in front of them and provide that there is a benefit? We're increasing the cost.
Every year, we attempt to increase our responsiveness, speed, our work on cases, everything, trying to increase our benefits, but I'm not quite done. But what year was it that there was a 7% inflation? Was that 22 or something like that? I mean, inflation over the 22 years since the last fee increase, I can only imagine that is significantly more than 10%. So in that regard, we're actually charging people less.
And I'm not opposed to
that's
the increase. I just want to make sure
Right.
that we are vocal in whatever method we use to describe that there's a benefit. We talked at past board meetings about the not providing wall certificates, or not charging for wall certificates and stuff like that, which, that's a benefit to not charging for something. It's a benefit getting back. But have all those other things that we are doing, are they being discussed and put out to the registrants as this is a benefit?
I think the things that Greg writes up probably show a lot of benefits, and certainly speed of responsiveness would be one of the ones we want to.
Last year, we had maybe 5 or 6 outreach events. I think I'm up to about 12 for this year.
Yeah, it's a good story.
And that's in the next 4 or 5 months. So
Chris?
I did find something on inflation I'll send to you. Which
I'm very curious.
it's worse than you think, so.
So I think answering your question partially, Aaron, too, is that we used a pretty conservative on both ends of the expense increase per year percentage as well as a rate increase. Because at one point we were looking at almost 20% of an increase, and we really honed into minimizing. But you look at the table, we're not exceeding in profit. We're actually staying, hit into the negative again when we're starting to reduce our fund balance, and that's at a 1% expense increase and a 10% fee increase. And not 10% per year, but 10% flat starting in January 2025. So the benefit ratio, I think I would say we have some mandatory requirements that we have to pay for, that our central services costs are going up. We have some work that's included in our budget that's going to happen with the Department of Licensing, and some costs that we're going to probably have to be charged into as they go through some upgrades. We have a One Washington, major approach to all of Washington State going to a financial system that's under Salesforce. That's going to cost us time, effort, and money. So all these costs are included in that increase. And then as well as an increase for your director, the salary increase for your director, to basically an overlap position, and that increase of another position, 3 positions we're bringing in a different level. And so those are places that we've known we've had to go and get to. We've just realized the fact that these are the positions that are going to cost us money. I can flat out tell you the director's increase is not my idea. I want you to know that. I don't care. I don't want it to be there, but we're being told by OFM and our group that we have to correct our positions and our salaries to a level that makes sense. Or when I leave, you're not going to be able to recruit anybody. We're out of balance right now with my position level. So it's a minor amount, but it's part of something we have to explain. It's what we have to do. And so getting there, yes, it's what is it going to be? $14 at 2 years increase for us. And so explaining how that benefit's going to be from $14 to $7 a year. What are they getting for this? They're going to get an LMS system and it's going to help our applications get through, but also it's going to improve our statement of charges, because we're talking about AI or statement of charges. We're talking about improvements, and that's why we're hiring an MA4. We want a technical savvy person that can bring us to more electronic ability, do things more efficient, to bring better service, better phone call operations, whatever we need to do. We want to improve as an agency. We've gotten this far by shoestrings, and I don't mean that badly, but I think we've gotten this far. Now we need to improve ourselves, and that's all we're asking for. And even with that small increase in that improvement, we're still going to, if we don't do that, we're still going to be in the red. So we have to come in with an increase. And if it's 5% and we don't do anything to improve the services, so what is that? Now $7, so $350 a year cost increase for people. Or we can go this direction and have this upward scale of what we're doing as an organization for an extra $7, per registrant. So how does that fit with the cost benefit ratio?
What business that's still solvent hasn't raised their rates in the last 22 years? I mean.
Maureen? So I guess to Aaron's point, if we could just be more transparent with our constituents, that, we're raising our rates after 22 years. And these are all the things that the organization has done in that time that is the value to our members.
Yeah.
But because people don't really realize behind the scenes what you guys have been doing, right? And the things you've been putting in place over the last 20 years to make our lives better as registered professionals, and the efficiencies and all these things. And it's just kind of like this is the value you're getting. We haven't been charging you for it in the past 20 years, but now we kind of need to course correct.
Yeah. And certainly it's whether right, wrong, or indifferent, it is one of those components of threats to licensure. Threats that are national, threats to regulatory boards that are people looking at. And the legislature looking at whether.
The fee is?
Yeah, increasing that fee. So it's just one more.
So I will work with
Yeah.
Greg and Ken so
Yeah.
that we have some good, documentation, it's either website or the journal that will be coming out in the fall. And that, we have a way, and maybe it's a statement that goes with every renewal once this goes in. We didn't talk about timing. We're wanting to get this moved forward so that we have the information to DOL to change Polaris before the first of the year, because they have said to us they're changing to this one Washington new accounting system, and they don't want to do anything for us on Polaris after the first of the year.
But they're also doing fee increases, and if we can piggyback onto what they're doing, it is a cost benefit for us with the Polaris changes, and they're getting that done by the first of the year before they hit all this one Washington stuff, so.
And
That's
so
the
will
time.
the renewals go out before that, or?
30 day, the notice will go out, so we have to have the notices out in time, so people that are gonna renew on January 1st have got the notice and they can do their business with an extra $14.
Yeah.
That 120 days is September. We were gonna talk to DOL to see if they could change it from 120 days to whatever.
So I wanted to clarify just from my recall here. We have the drafted revisions of the code. We have the 101 already on file.
Yes.
So this is an advancement of CR 1 and 2 with those changes about.
All right, so, yeah.
Clarification, this is mostly inflation, not loss of revenue due to licensure.
I think he's taken into account both, but it is mostly inflation of our expenses.
Yeah, if you,
More than loss of revenue from
Dropping.
dropping.
Licenses.
Is that fair to say, Ian, that it's not so much fewer renewals, it's more about the increased expenses?
The figures in this packet do not model for changes in your licensing numbers. So if you add that layer in, if folks are expecting a decrease in the number of licensees, that would make a fee percentage increase that much more pertinent.
Okay.
That's flat.
Any other questions, discussion? You moved.
Yes.
Seconded. Maureen seconded. For the fee increases as noted. All those in favor say aye.
Aye.
Opposed? Okay, so the fee amounts have been approved. Now I want to talk a little bit about the fact that Shannon has given us two versions of the language for, sorry, too many numbers in my head. WAC 196.26A. So it's 196.26A covers the fees for professional engineers and land surveyors. So the first option is to only change the fee numbers. Is that right?
Right, and add the change of fee numbers and add that legal background.
Right.
Language.
Yeah.
Right, there was, some language about,
Reporting. Legal background.
right, she's reporting her
Which was already approved.
criminal.
Yeah. It's just. Yeah, and everything.
Okay, so that would be the second one. This first one in here, I worked with Shannon. We did a little back and forth to look at this language that removes section 196-30 because that is a section of the on-site designers and inspectors that repeats a lot of the same language that's in the engineers and surveyors. And so she worked to kind of clean up the language such that the table has everybody's application and renewal fees. And also gets rid of some of the things like the examination cost for NCWS is actually paid to NCWS, so that is not part of this fee that we collect. And a couple of little nuanced changes there that if we move forward with decoupling, we won't have to change that language again because those fees go to NCWS, whether it's before or after somebody comes to us and is not relevant in this fee section anymore. So that's all in that first version. And really, we need an hour to kind of go through this to really convince you that it's all there, but I have gone through it with her. The second version, it's the reveal and full changes. The second version is if we just say, look, let's not spend a lot of time on language, let's go straight to changing the renewal application fee numbers. So that's up for consideration.
And I will say, I just realized that if we choose to only change the renewal stuff, we will still have to go in there and change Department of Licensing Director to.
Oh, yeah.
In some of the other sections.
Oh,
I just realized that when I saw it, I went, oops.
yeah, right.
Yeah, we will have to change in the first section, especially where.
There was good cleanup in that cleanup version.
Yeah.
Would be worth it.
So it's in the motion, just change the proposed fees. The questions, the context, right?
Yes.
And did we, if I may ask, right, we're not technically in discussion yet, we don't have any. Do we already have a motion? We already have a CR 101 addressing 19630.
The 101 says, I brought it up.
I want to make sure things are in scope.
It says, actually, we included both.
See,
We included
I
both.
would like to 9630 be discontinued, repealed as the language and the appropriate compatible conditions regarding fees be moved to the 19626. And
Including other
including
cleanup.
other cleanup.
So the full cleanup version. All right, we have a motion.
Second.
Maureen seconds it. So Dave moved, Maureen seconded that we,
Doug.
I'm sorry,
We look just the same.
I need to go play ping pong. Doug moved, Maureen seconded that we proceed with the CR 102 of the full version cleanup of the fee sections of chapter 196
With the
and include the fee changes as well as the editorial. Is there any further discussion? Dave?
Now, I understand that this increases the risk that it won't be ready for the fee increase by the time it moves to get into the system, right? Because this is a bigger mouthful than just changing the fees version.
That's a question for Shannon.
I don't think it will if we explain it correctly. Because a lot of it that I'm asking to get rid of language out of 196.26A is because it's in another section of our WAC. Like the application part is already in, another part of there, and the corporation stuff is already in 196.25. And I don't know why, we doubled up on language and we just need to get, it's just language that's somewhere else.
Yeah.
Okay. And the parts of that are on-site specific for renewals were added into the new language.
Who could slow us down?
Us. I can't see anybody there, if anything's gonna slow us down, it's gonna be because they have to pay extra money a year and I can't even see.
Yeah, it would
We're
be,
not increasing it that much, but.
the only place we'd get slowed down is if it went to JARC, right?
And JARC would probably be like, thank you for cleaning up your language.
So that would be the risk if we
Yeah.
if we got stopped and turned around at the
But that's usually after
legislature.
103, I think.
Yeah, JARC doesn't get involved. hardly
Unless
ever.
somebody petitions them.
Right, and which nobody does, but they do get involved with big organizations, big agencies and big changes. Like, yeah, people end up working with them all the time, but this board is that.
I just can't see anything.
Is there a small business notification thingy, whatever that's called, that you have to do?
Oh, Ken did the threshold calculator.
Yeah.
And I also, there's an exception. Don't do it.
Sorry, yeah.
Don't- It's not just that we don't have to do it. You keep saying you did that and I appreciate it. It's wonderful.
Yeah.
But there's an exception in the statute.
We have to note the exception when we file 102. We have to note it. Right, we need it, so.
Okay.
And it would have to be significant opposition during the 102 outreach for us to stop it. If you have one or two people, you can still move forward.
Right.
It's just significant, so.
Right.
And I think Shannon, what you stated is probably the most golden statement is that the objection we would get would be on the shortened version, not on the long version. So the risks of the long version aren't any different than the short version.
It's just, yeah, when we put the 102 and the language on there, we could have a document that says, this is what we changed and why. This is why we're repealing this.
Yeah, it's good sense.
And I think if it's explained, it would get less comment.
So the language before us includes the passage of the motion.
Yes.
Okay.
Just happens to have passage in the previous motion.
But the previous motion only was the renewal
Was
portion,
the,
right?
the
Not the,
numbers.
not the application fees for the examination,
Correct, just.
just renewal. And,
Right, both of them are just renewals.
okay, and in the analysis of Ian, there's no other changes that we need to make to applications or examination.
That's correct.
Okay.
Yeah.
It's just on the renewal.
Well, there are changes, like comedy, right? Mentioning comedy the same,
Yeah,
that's a change.
right.
Well, we just moved comedy out of a section that was by itself and put it under applications. So
Right.
Yes, it's still gonna be.
Its
still
number,
under 10.
its number increases the same.
I thought you wanted to make it the same as.
The city fees. We never, but we went no. Based on Ian's objections, we only had to change renewals.
Okay.
But when they renew after their comedy license, guess what?
Yeah, because, right, comedy is the application. But
Okay, so again, we're current on this.
yes, and I will take another very thorough through it.
Yeah.
With Shannon, if we move forward with this full language.
Yeah, and I'll make sure it was what we said too.
Yeah, some structural engineering things, exam things that still need to be
Yeah, it's
edited.
all wonky.
But they're just,
Can we look at page 9 of this, at least what's in the packet, which I guess is page 65 of 98 in the package? It's just 5 of 98.
Five.
5, at the bottom.
We're looking at the fee numbers.
Yes, why do those, aren't those the old fee numbers?
Yes, because we, I think because we didn't get, I think it's because we didn't get the final.
So you left the old numbers knowing that would be. Yeah.
Separated, we set the numbers.
Right.
And now we're saying move the CR 102.
I will make sure that it gets reviewed by.
Yeah, we'll take a good sharp.
Right, so the 102, the language still can be changed. This 103 is on. So straight.
Choose what you're proposing out there.
Yeah.
Any further comment before we take a vote? All those in favor of the motion to go with the full language of the changes to chapter 196 for fees, please say aye.
Aye.
Opposed? Okay, motion passes. Thank you, Beth. Thank you. Fabulous. Move that forward.
Madam Chair.
Yes.
One question that I did have that I didn't want to mess up with this past motion here, but can I get a little bit of background on 196.26A 100 suspended fees?
Oh, yeah, so in 2014, when we started doing, well, when NCAA started computer-based testing, we allowed applicants, if they had the ABET degree, to go directly to NCAAS. And so that just let people applying on a, long form by experience only, foreign degrees, they had to come to the board, and the board felt they shouldn't have to pay for an application to take an exam, and these people got to take it free, so they suspended the fees, they didn't want to get rid of them. So those EIT and LSIT application fees have been suspended for the last 10 years. And I think in this language, it's probably, we unsuspended them. We just took out that language, and so it's a $30 application fee. And it's a $30 certification fee, so they're not required to pay it unless they want to be certified.
It's just confusing.
Yes, it is.
Well, yeah, and they will be paying something that their predecessors for the last 10 years have not.
Yeah, and we get about 100 a month, Mackenzie? More than
Yeah,
that,
it's a high amount that we get.
for just certification. So,
Just sending out the lawsuits.
yeah.
Processing.
Okay, item 6, director's report. 6.1 is financial report.
Ian, it's still online.
Do we want to have Ian do any further
If you have questions,
report? If anybody has a question about the current biennium reporting for Ian?
You know, as in committee work and reviews and packet. Thank you, Ian. It's been a nice detail and assessment. Observe that generally where we expect it to be, a little bit high on some DOL costs in after action, so to speak, from the last fiscal, but otherwise it looks good, and I appreciate your effort.
All right, anything further with financial reporting?
no,
Let's move on to agency operations, 6.2.
okay, Chris,
Yes.
I put you in the spike and throw it back at me.
No, it's fine. We've talked a little bit about changes in staffing. That's probably one of the bigger things that we have going on right now as far as agency operations. We are reallocating all 3 of the licensing customer service staff from customer service specialists to professional licensing representatives because it actually fits what they actually do. So with that comes some changes because the PLR 1 designation allows them to review and recommend for approval applications, but they cannot approve them, which is what staff has been doing as customer service specialists. So Ken and I have been talking, we've been talking with Vana. So Ken and I will be meeting with staff every Monday morning, licensing staff. They'll be producing a report for us on all of the recommended for approval applications. Ken and I will we haven't worked it out fully yet. We're still sort of in the process of figuring out what this is going to look like where we don't hold up approvals. Is we're going to look at those, discuss it with the licensing staff. Ken and I will randomly pull some to look at. And then we will be making the official approvals. So we'll approve it, then staff will go in and with the approval in Polaris and we'll move on. So it's something we went round and round about a little bit with OFM on this, and we think really this is the way the board is moving anyway, based on some discussions, and especially with EQC of board members wanting to see some of the applications. We're just now doing it in-house also for that actual approval. So you guys have questions about that?
And if I can add to go along with the process that Chris is describing, we're also developing a policy that outlines that process.
Yes.
Yeah, so best I can assess, you got about 100 a week. So what's that gonna do burning you guys out?
Well, it's actually, we're not going to look at every single one.
Oh, I understand.
But yes. We'll have an hour meeting every Monday morning with staff, which I already have a half-hour one with licensing staff. Ken will just be pulled in at least for a half an hour of it where we'll talk about the applications and we'll go through it. We don't know what this process is going to fully look like yet. We're just trying something out, seeing how it goes. We'll probably have to make adjustments along the way because we don't want to burn us out and we don't want to overburden staff and we don't want to hold up applications. So.
And the position descriptions and authorities are not malleable.
To make it so that staff would be able to approve, is a PLR2, and a PLR2 is a much higher level of leadership, which is not fitting for the rest of the work that the licensing staff does. So there's nothing else in designation of OFM positions that fits. We looked.
The answer is yes, we can't.
We tried. Yeah, we tried to come up with, okay, well, if we do this training and we have this, then can they approve? And the answer was no. And they'll get some training anyway, because we want to make sure as they review and recommend that they know what they're looking at. And,
This process itself would be much helped and more efficient if it were all NCWS records too. And
which a
because,
lot of them are.
and so, yeah, and so reviewing those are much simpler than us putting together our pieces and parts and scanning them and, you know, whatever the applicant sends in plus the application. And so I think we can make, you know, some of the review may be coming right from NCWS as well. So
there is a large percentage that come through in CES currently. I think this also gives Ken and I an opportunity to get a firm grasp on licensing. I mean, I'm still figuring it out, you know, and are there changes we need to make? Are there lean processes we need to do? Are things working well? You know, it's an opportunity for us also to be a little bit. Our staff is so good. They just, you know, they just keep things moving. That it's very easy when people do that to not really dig into it because nothing's bubbling to the surface, but is there something under the surface we're not seeing? So
Yeah,
not saying that there is, but it's an opportunity for us to just know.
yeah, and
Yeah.
we'll adjust it. I think we're gonna meet on Monday and talk about it. If it needs to be twice a week, we meet with staff that, or it gets shipped off to us and we, we'll work it out. And I think you guys holding us accountable to making sure the machine's still moving efficiently. And I mean, we're probably gonna slow it down a little bit, but hopefully we'll stay at least
If we,
slowing down during the week and not slowing down where we ramp up behind the scene as the month goes on.
if we slow it down a week, that's acceptable because we're still much faster than most other states. So if we slow it down a week, I've talked with staff and they said, yeah, that's acceptable. That's something they can work with, so. We'll see how that goes, but that's a change that we're doing in the process. Of course, we're double filling Gil's position. That's going to be advertised next week. So we'll have that open for 3 weeks and then we'll do interviews and hopefully have somebody on board in October. To double fill, and the plan is for Jill to train and then probably the last, 4 months that Jill is there for that person to be doing the job and her to be their support so that they really get that hands on. So we'll do that switch over about halfway through. And then the hiring for the management analyst 4 will be sometime in the fall. That's when we'll advertise. We want to be very thoughtful about the position description, what really it is that we want and what we're looking for, but Ken and I are already seeing where that person can fill some of these gaps, take on some of what is overflowing on people's plates, and we're excited about that opportunity too.
I'm sorry, what was that position? It's a management analyst 4, which is basically gonna be the licensing examination program manager, which Vonna, me, and Emily currently are under, and Chris has been basically taking that workload on, with Vonna stepping up in several of those areas, but it spread everything pretty thin across that group, and so bringing someone to take that on brings some efficiencies, technical improvements, the learning management system.
This position will be coming in and looking at what we do and how can we do it better. And they'll all be taking on some of these, I'll call them projects, and looking into, hey, we would like to be able to use AI to do some things within the agency. But we need somebody to have time to really look into it. What's the best practices? What is the state already saying we can do? What can't we do? Working with Law Tech, helping put together policies on it, guidelines for staff. Any other opportunities that come along, the licensing or the learning management system, we've hit a bit of a roadblock there. We need someone to come in and spend time really looking at our needs. What's the best way to go? How can we get what we need? When it comes to exam preparation, not preparation, but exam development and security and all of those things, having them really look at that in a broader sense, be a connection with UL, be a connection with NCES, and coming in and looking at what we do, how can we do it better? It's a way to really elevate us as an agency. And as a board in what we do and how we do it. And then also to just fill in some of those gaps that like Ken and I can't get to, we're trying to do. Maybe even Greg, with outreach, how can Greg, with what he's trying to do, he has a very, very full plate and we keep, throwing more at him, even Shannon with regulatory stuff. So it's pretty broad, the position, what the position is allowed to do within the description at OFM. So we can tailor it to our needs, we can keep it broad, but they do have a little more of a technical background. So they have an understanding of some of those technical needs and processes.
But we're not duplicating a position.
We are not, this is new.
You're our 11th employee.
10% case.
Well, let me put, just my observation. Okay, you want to say something?
I'm gonna say, I think you guys have talked and defended that well. I think we have relied upon our director and you to run the organization. And so we support your actions and motions in this regard.
I think the only other thing I have that's kind of exciting news is that you guys may or may not be aware that when the agency or the board, when the board left DOL, we had information, licensing and investigation records that were in the old system Venture. And we were supposed to get that information and we never did. So it took a year almost, but we finally got it. It's available, it's accessible to staff now, and we have our information and it's within our hands. We own it, we have it. It's out of DOL now and we can access it. So it's just older licensing records and investigation and compliance. So yeah, that was a big push for us, for them to get that. It was a lot of work on it, but they promised it.
And it's
so.
separately secured off on its own equipment.
It's on its own
Locked
hard drive.
office, not tied to the internet.
Yeah.
Or browser.
Mhm.
Stuck in this warehouse down the street.
Nope. No, it's next to the Scantron machine.
Which is its own separate.
Yeah.
Thank you, Craig. Any questions? Oh, lease renewal, did we talk last in the executive session? We are opening discussions, Mackenzie and team.
To be able to stay where we're at.
Lease renewal in our current space, still not quite a done deal. We're still in the negotiations with DES. An update on that.
Yeah, on the 14th, I have a walk through a deferred maintenance block with DES, their real estate folks and facilities group, to just walk through our building and make sure that we're going to get what we want when it comes to maintenance on the building with the new lease.
Okay.
Yeah, and then additionally, audit.
Yeah, the two other things I have too, we're entering into the audit timeframe. We've been talking about this accountability audit coming. I've been in communications with the state auditor's office and we will begin that accountability audit in October. It's about 60%, 60%, let's see, planning and 40% field work. I might have gotten those mixed up, but it's not a whole lot of that chunk from October to December. It's mostly going to be occurring in November when really they'll be asking for documents.
And we pay the state auditor to audit us. So that comes out of our budget.
7,000. Yeah. So preparing for that. And then other than that audit, we're going through annual reporting, which is very, very robust. There's 8 different reports that we produce that I work on, and that really is from September 1st. Well, now in August, but September 1st all the way through December 31st. So that'll be something that's going on at the same time as well.
And then we're beginning the first stages of performance review type things. Chris and I are starting to look at annual performance reviews and giving updates and all that for all staff. So that'll be coming through in the year.
Yeah.
Any other agency operations questions, comments? Okay.
May have noticed that we are not doing reports by every staff member this time. So look at the reports that they provide for licensing, and if you have any questions, then certainly we'll have them answered, but we're not going to have everybody report out on their tasks.
I don't have any other items. Should I have any? Okay. Thank you.
Okay. On to 7.1. Kinsey, can you let me know whether there's any public?
We do not. It looks like we've got Ian Shelley and Mike Verney on them.
Okay. Ian, you're welcome to sign off if you want, or I believe we're done with anything that we'll ask of you. Thank you for joining us today. Mike,
Sounds great.
Thank you, Ian.
all right, thanks. Item 7.2, upcoming outreach and events, that's Greg.
Upcoming outreach and events, so I'll run through the calendar here quickly, things that are coming up. We do have a PWA Kennewick. That's coming up in October. Similar to the spring meeting, this is the fall meeting that they have. We very successfully had a booth there, targeting especially volume of preservation. Another event coming up this next fall is Gonzaga in Spokane for meet and greet at board meeting. We're about halfway through planning for that. Also coming up soon is the Washington Career and Tech Training Fair in Grand Mound, which I believe would be a good place to target for interested surveyors. Yeah, it's a technical fair, essentially a job fair. We do have an on-site workshop that's coming up in Spokane. Also this fall, as last year's Septicon in Tacoma. A real big one for us this year, a new one, is a home and garden show in Tacoma, at the Tacoma. And we've rented space there. A lot of foot traffic, as you might expect. This is an opportunity for us to address homeowners, property owners, property managers, about hiring professional engineers, land surveyors on site. So it is fishing where the fish are. And we're working on audience and messaging and all those things for that. So that's exciting for us. And then, of course, coming up, we're coming up again on another LSAW meeting, just want to get to it. So, any questions about any of those? Just the ones up through, I guess they still over in January, but lots of things happen.
And you'll see those on the calendar at the next board meeting, extend the full year. And I do have one more to add to that I'd just like to mention. We have an upcoming summer staff day for our all staff group. We're really, really excited about it as an agency because we've talked about doing this for years. And because of the volume of work, how busy we've been and everything else going on, COVID, et cetera, we haven't made that happen. So Bryce has really taken the lead for employee engagement and he's helped set that up for us. So the 20th in August, we're going to be doing that. The office will be closed, so we'll have some messages out there to the public. If they reach us, they'll hear that we are out of office. We're really excited that we'll be doing an escape room team building event. So it'll be great to see how our team works through that together. And really a lot of team building activities are going to be going on that day.
And two other things to mention quickly, as Marjorie mentioned earlier, a lot of work now going on the website as we work towards the home stretch with that. We're done with beta testing. Thank you to everyone who did help with beta testing, by the way. And Kenzie and I in particular are working very closely with Law Tech. And the other thing was just a plug for LinkedIn. For those of you that haven't got a LinkedIn account, please do, and please like, share. Our LinkedIn page, that is the only way to ensure it all. We are up to about 75 folks following us, but to keep increasing that, the only way we have to do that is for people to like and share. So please do. Thank you.
You're going to eventually get all 45,000 licensees.
I'm working on that.
That's great. Okay, so Jim, you've had
One additional outreach is the next Wednesday on the 14th, that'll be virtually, pending LSAW Board of Directors meeting virtually. Talk about SMEs, recruiting SMEs and the board member.
All right.
Good. Okay.
Thank you.
And I'm sorry, Jim, you said that was next week on the 14th?
Yes.
All right, 7.3 board staff affiliate involvement. Nothing to read. Oh, this, okay, I'm sorry. It changes names on me. So this is if you're on an NCWS committee and you want to report out on things that have happened within the last 2 months, or LSAW, or NSPE, or any other affiliates. Okay.
Did you see the email? I didn't realize Chen's getting an award at the annual meeting.
Just to Ken and which
So, NCAA.
So I'm actually going to be interviewed on video there, and I don't know when they're going, where or what they're gonna do with the video, but they've asked me to
That's pretty cool.
speak. Yeah.
Pardon?
It's very central.
NCAAS is giving him a distinguished service.
Oh, an award. I thought you said he's getting going on the board.
Yeah.
If someone can get a picture of him with the award.
We will definitely make that.
Well, we won't have a good cameraman then, so we'll have to borrow a camera, right?
Every camera's a good camera.
Okay, it's just
Every
the,
camera's a good camera.
just the.
All right, so any other comments from any other organizations? Doug?
You know, there's not really a status yet because most of that committee work is I had been in some recess. I have been asked to be on the NCES examination policy and preparation, policy and procedure committee. I've been asked by NSPE to be on their policy advisory committee, the COPA. Been asked by the AICHE to be on their licensure professional development committee. Again, they were in kind of recess for a couple of years and COVID essentially.
Who's that?
The chemical engineering. And the state and the WSP, the State Engineering Society, has elected me to be their delegate to the National Society's House of Delegates, which means I'll be representing the state to the national board. I'm a recycle. I did this in 8, 10, 12, and then on the board of directors from 12 to 14. So it's not new territory.
Okay, thank you. Thank you for doing all those things. 7.4, action items from this meeting. Can you walk us through that?
Yeah, do you want to speak to the difference on the action items list?
Yeah, I asked staff to not repeat the action items that are in the committee reports and to clean up the action item list so that it wasn't 3 pages, that we move forward on trying to get actions taken care of or report. You know, I'd kind of like to know each time if an action's not being cleared, what has been done so far on it. So is that right? Mackenzie, is that kind of?
Yeah, possibly add to that is that you might see more action items lingering on those committee agendas or reports if they're still being worked on.
Oh, we still do have them on here. Okay.
There are some that we've kept on there that we felt we needed to keep here. But you'll start seeing them a lot more on those committee agendas.
Okay.
Okay. And action items from this meeting. So there was quite a lot of discussion, so let me know if I need to revamp any of these. So first we've got Jill to bring the disciplinary timeline report to PC for review and adjustments. Ms. Lund, excuse me, the short on the first one, Ms. Lund will direct EQC to review the California seismic exam. Once the report is received from structural committee, they'll look at updated logistics and ramifications. So EQC will look at logistics and ramifications of that seismic exam. Oh, let's move over to this big one I wrote. The PC to revise definition of engineer as used in the chapter and add professional in front of the words engineer and land surveyor throughout the chapter 1843. staff to send a SharePoint link to the 1843 Task Force questionnaire results to the board members. EQC to move forward looking at language for 1843 as it applies to our current transit processing applications. I don't have anybody assigned here, but to move forward with fee increases of, I apologize, I didn't move it over here. Here with me. So to move forward with fee increases of $128 for professional license renewals, $64 for late fees, and $121 for certificate of authorization renewal fees.
I would make sure you use the right preposition, that the word is to rather than of. So not increasing it by 100. It's got a word.
To. Thank you, Dad. Board staff to advance CR 102 for WAC 196.16.120. And board staff to proceed with CR 102 of full changes to WAC 196.26A, including the repeal of WAC 196.30. Did I miss anything on that last one?
I think that's right.
Okay. And that's all I capture.
Okay, anybody have any other action items for Mackenzie?
But the PC was assigned to safety to professional type language.
Yeah,
You already covered
I
that.
think you covered that.
I had to flip around for it, but I
Yeah.
do have it there.
I wrote down that the EQC was to review our comedy application for how we ensure an applicant has knowledge of Washington's applicable codes.
Did that come directly from EQC or was that action coming from this meeting?
It was, I have it under our discussion about the MRA.
Oh, yeah.
So I thought it was a large, Ms. Lynch's request.
Can you repeat that to me again, Maureen?
Want the EQC to review our comedy application for how we ensure applicant has knowledge of Washington's applicable codes.
Yeah.
Do you remember?
I said, well, yeah, that was,
Direction, but
I think it was, doesn't that mean foreign comedy, not comedy?
it could be either.
Okay.
And this relates to, number one, do we want civil structural PEs to take a seismic, an additional seismic exam? That's one piece. And the other is perhaps a way of addressing foreign and other states coming into our state is to just have an attestation on our application or on the law. That was the thing that I think I talked about. It's either change the law exam to say, I attest that I have studied the local codes for jurisdictions that I'll be working in. That,
Thank you.
so yeah, thanks, Marina.
Thank you, Maureen.
Not very good at writing these days. Get sidetracked.
You're right, because what I wrote down is that for an application, review the policy. Maybe that's where I got it.
Okay, that's it for action items. Let's talk about agenda items for next meeting.
And I apologize, I forgot to write down the regular ones, so I'll just try to do those off the top of my head. So the one that I captured from this meeting is approval of the exam policy.
Yes.
That was all I captured from this meeting. Some regular items.
that would be coming out of you.
Yes. The other regular item would be to select board meeting dates.
Is that what we do in October?
Yeah, for the upcoming year.
So the rest are anything that comes out of any committee if they finish with decoupling and or any of the other issues on the table.
Yes.
Okay. Anybody have anything else to add to the agenda at this point? All right, so item 8, adjourn meeting. Would entertain a motion.
Jim said so moved.
Jim has moved.
Second.
Maureen has seconded to adjourn the meeting. Is there any discussion? All those in favor of adjourning the meeting, please say aye.
Aye.
Opposed? Meeting adjourned. Thank you. This, I
Thank you,
think,
Mike.
is the
You're welcome.
longest meeting.
Before I log off here, I'm just out of my own curiosity. Does anybody ever oppose that motion?